themselves. I have filed all the things and all the documents in my affidavit.
My lord. My lord, that DMT matter which becomes infructuous as the training process is going on, my lord, can't be listed. Earlier it was listed, but it was not reached, my lord.
So when do you want?
No, can't be listed tomorrow. Otherwise it will be infructuous.
Oh, we thought that it had already become infructuous. That's what the
No.
no. Give your slip.
Because you said has become, so we thought that it will become.
May I be pardoned, Your Lordship? Your Lordship, a review application was filed. We want to withdraw the review application. Your Lordship, the only difficulty is the D number. It's still in the diary number. Your
All that
Lordship,
can be listed.
Lordship may be kind enough to ignore the defects and list it for withdrawal. Obliged.
My lord, I have a prayer. And personally, some inconvenience will be
Yes, yes.
item number 5, fresh admission.
Whatever, if it is.
Can it be tomorrow or day after tomorrow, my lord?
Anytime. Senior counsel. Request, how can we
Sorry,
refuse?
inconvenience, my lord. Tomorrow or day after, any day.
All right. So ask someone to be here when the matter is called so that
Yes,
we may fix.
For judgment item number 1.
We do not find any merit in the petition. Just this one.
For orders item number 12.
Not there today.
Not that today the I has been filed to recall the order, which is not the writ application dismissed on merit, my lords. So how can,
But in his absence.
yeah, only ground is absent, so it cannot be, I is not maintainable. my lords.
There is no representation on behalf of the petitioner by filing IA number so and so. The petitioner seeks to recall an order dated 16/3/2022 passed in WPC number 17248 of 2014. So we are prima facie of the view that this interlocutory application in a disposed of matter for recall of the order attained. So, however, since land counsel for the petitioner is not present, the matter is adjourned to tomorrow.
Item number 13.
Item 13, there is 139 days delay.
Yes. Notice.
Notice.
You have stated that it has been disposed of on the basis of the order passed in WPC number so and so. But you have not given what is that order.
That's page 38 is the order.
Page 38. Order passed in WPC 7846. Is there?
No, that is order part in 1619,
Yes, 1619 is the impugned order.
16196,
What is that impugned order?
16196,
Yes, what is that impugned order?
page 38. Madam.
Yes. Writ petition is covered by so and so.
Well,
So should you not give a copy of that order?
yes, yes. Madam. That
And have you challenged that order?
Yes, that has been challenged. Yep. This matter will also remember that medical
Yes.
sub matter. It will be, after some days it may be infectious because of the politicians. So you will also urgent this matter for 2 weeks so that because the government is taking a policy. A batch of writ appeals shall also disposed of. A batch of writ appeals shall also.
So we are just.
So that was filed by private respondents. This is filed by the speaker. Two contradictory orders are there. You will also urgent this matter for some days.
So whether the state has taken a policy.
No, my lord. For that reason, I am saying that for says your lordship urgent it.
To give that number on which.
Your lordship has disposed of the number of writ appeals. That
This order is based.
yes, I will give that. No. It might.
Please, next.
Well.
List this case on what is it? First. This case on 11/11/2024 to enable the MK Puntial and additional government advocate to obtain instructions if a policy decision has been taken by the government.
Yes.
Policy decision has been taken by the government.
Item 14.
Item 14, well, 58 days delay. That similar matters are fixed to 11th November.
So shall we issue note? Anybody is appeared? Shall we issue notice?
Yes, ma'am. On the question of limitation, you will also issue.
Notice the question of the condemnation of delay. Returnable within list the case on 11/11/2024 along with connected matters. Sorry. Acha, sorry. Has to requisite within 3 days.
Item 15.
Item 15, well, 134 days delay. This Lordship may issue notice on the question of limitation. Similar matter, it may be tagged with similar matter WA number 432 of 2022.
WA
32 of 2022.
any date?
Date November, that has been
Mr.
19th.
Puntia, Learned Additional Government Advocate submits that this matter is similar to WA number
32 of 2022.
32 of 2022. Full stop. For the full stop. If you notice in the question of condemnation of delay, returnable within 3 weeks, list the matter on 18. Let it be listed along with that. Let us see.
Right.
It's connected to WA 432 of 2022, which is posted to 4/11/2024. Sorry, 24. This is the case on 4/11/2024. Sorry, 5/11/2020.
Item 16.
The delay of more than 1102 days,
1256 days.
1256 days.
What is the point?
Point, my lord, on the very first day of admission, the writ petition was disposed of with a direction to regularize the service of the petitioner.
Consider in light of. Has it been directed that you consider in the light of? or to
Consider and regularize. The word is consider and regularize. Lordship may kindly see.
Page?
My lord, page 6. Sorry,
Which item is it?
16.
16.
Which correction?
My lord,
It's one. No. You can seek review of this order. Due to seize were call given by the members of. Consider the case of.
my lord,
No,
consider the case of the petitioner and regularize his service, keeping in view.
We can clarify. We just clarify without interference.
The Lordship can clarify that the authorities will only consider in accordance with law. But that can be done.
The present appeal. Inter-court appeal has been filed. Putting to challenge an order dated 25/10/2019 passed in WPC number 19974 of 2019, which reads as under. The appeal is barred by limitation. Stop. There is delay of
1200.
1256.
on facts. Next, when AGA challenging the impugned order has said that the same was passed on the very first day when the case was taken up without any opportunity to the estate to file a counter affidavit with a positive direction to the state to regularize the petitioner's service in the light of the Supreme Court's decision in case of Secretary of State of Karnataka and others versus Uma Devi, bracket 3 and others, reported in 2006, volume 4, FCC, page 1. Stop. Next. We have carefully perused the impugned order dated 25/10/2019. Stop. In our opinion, the said order, in our opinion, in the light of the nature of the order passed, the same does not peculiar facts and circumstances of the case as the order was passed, impugned order was passed when there was a call given by members of Odisha High Court Bar Association to cease work, and there was no representation on behalf of the parties, particularly in the nature of the order which has been passed by the learned single judge, we are inclined to dispose of the present appeal without interfering with the said order. The only clarification that in terms of the said order of this of the learned single judge, the opposite parties are required to consider the petitioner's case in the light of Secretary of State of Karnataka and others versus Uma Devi bracketed supra, and regularize his services if he is found entitled to in terms of this decision of the Supreme Court. The clarification, this appeal stands disposed of. The interrogatory IAS stands also stands disposed.
Item number 17.
There is a delay of 127 days.
159 days.
One
Does it matter?
matter, my lord, initially the petitioner prior to 2005, that is the cutoff fixed in the pension rules, that anyone appointed after that date not entitled for GPF pension. Case of the petitioner was initially appointed prior to 1/1/2005 on contractual basis, but brought under the regular establishment after 1/1/2005. So she was not considered under the GPF pension.
You notice to the sole respondent on the question of condemnation of delay, returnable within 4 weeks, the refusals for which shall be filed by 25/10/24. List the case on
18th.
18/11/2024.
Item number 18.
18, my lord, there is a delay of 86 days, but it is similar to that item 16. The regular order of regularization on the very first day of admission.
So that is slightly different. It says ML Kesari and all that, not Uma Devi.
Yes, all the orders are same. If your lordship will find the operating portion, that is at page 20.
Now, this order is
The
different.
nature of order is same. In view of the matter, this court dispose of the writ petition, directing opposite parties to consider the case of the petitioner and regularize his service, keeping in view.
Oh, the operative portion is the same.
Yes,
And first day,
on first day. Order number 1.
no, but the party are present. Parties are present.
No, this is slightly different, Mister. Just see the operative portion. It does not say regularize. It says take a decision.
No, but consider the case of the petitioner and regularize his service.
Where?
If I'm
Am I looking at a wrong brief?
18, item 18, man.
Oh, then sorry. Then I am holding around.
Item
Just-
18.
No, item 18. Santosh Kumar Gowda. Yes. See the operative portion.
Right. Sorry.
That is not regularize. It says take a decision on the regularization.
Take a decision. Though this application, though the
Right?
My lord, I'm
so there is delay, the state of Orissa has put an order of this court dated 7/12/2021, passed in WPC number 39650 of 2021, a petty portion of which reads thus, paragraph 5. Though there is delay in filing the present inter-court appeal, we intend to dispose of the same at this stage itself in the light of the nature of order which has been passed by, of the impugned order which has been passed by the learned single judge as quoted above. Stop. The opposite parties were directed to examine and take action on the point of petitioner's regularization in the light of the Supreme Court's decision in the case of Uma Devi and ML Kesri. Uma Devi, ML Kesri, and Amar Kant Rai. Full stop. In such view of the matter, we are not inclined to interfere with the such view of the matter. We are of the opinion that there is no such order passed by the learned single judge which would require interference. So stop. The time, however, for taking a decision on the point of regularization is hereby extended by 3 weeks from today. Stop. The delay, IE number so and so stands disposal. Yes,
19 also same.
Item 19.
19 also same.
yes,
Item 20.
In item 20, there is 126 days delay. This is the rehabilitation assistance limitation.
Defect. Some defect.
I'll remove the defect within 3 days.
It can't be, remove the defect or relation of it? It won't be covered by that Bindu Sagar.
Yes, that Bindu sir, it will cover, particular because no one is appearing for
Okay,
that.
okay, all right. So that defect, can you remove in course of the day?
Within 2 days.
What is the defect? Okay. Page 22, 23, 35, page 22, 23, 33 to 37, yes.
Eligible copy.
tomorrow.
Within 3 days, because 3-4 pages.
K. Kunti, a learned additional government advocate, undertakes to furnish the legible copies by 24/10/2024, full stop. Issue notice on the question of limitation to the sole respondent, return requisites for which shall be filed by 25/10/2024. List the case. 18/11/2024.
Item 21.
Item 21, there is a delay of 90 days. And this is covered by W number 557 of 2022. You'll also reserve the judgment in that case.
which matter?
557 of 2022.
What is the matter?
That regarding that contract teacher matter. The Hindi contract teacher that no requisite qualification.
Yes.
And there is delay of 90 days.
And it is all right. I am for dispensing with, again, defect. Nikhila, what is the defect? First of all?
Why the defects are not removed?
Pages are not legible.
Pages, sometimes we are filing that copies. We will file that legible copies.
Do that. These matters should not come to the court. was pointed out that should be removed.
I'll remove within 3 days.
IA for dispensing with the filing of certified copies. This IA has been filed for dispensing with filing of certified copy of annexure
Annexure
2.
2, ma'am.
No, there are 2-3 orders.
The annexure
3.
3, page 47.
Sure.
Yes, ma'am.
Satyavrata Naik order has been set aside.
No, that order is reserved.
Okay. Certified copy of annexure 3. For the reason stated in the IA, for the reason stated in the application, comma, the prayer for dispensing with certified copy is allowed, the IA is accordingly disposed of. IA number 2684 of 2023. Issue notice. Issue notice on the question of limitation, returnable within 4 weeks, comma, requisites for which shall be filed by 25/10/2024. This is the case on 18/11, this is the case on 25/11/2024.
Item number 22.
My lord, similar to 18 and 19. There's a delay of 434 days. Same order. Consider the representation for regularization.
So one more line in the previous case, defect shall be removed. And he undertakes to remove the in 3 days. So the one you can dispose of it is
Item 40.
Item 22 years, delay of 440 days. So for that, another 10 was given. So you tell me
Follow the one. In that item 18.
18/19, huh?
18.
Item 23.
In item 23, 86 days delay, my lord. My learned friend has appeared. Once I can survey copy.
Copy of the opinion short.
Delay of
What is
86, we are condoning the delay, 86 days.
This can be also disposed of in terms of that Bindu Sagar Samant, right? If my learned friends
So
agree.
one order you show him.
I will give him your lordship call this matter tomorrow or day after tomorrow, so that I'll serve the copy of the writ appeal and also serve the copy of the order.
Next week. Get a copy of the.
No, it will be there.
All right.
So that we have taken.
All right, yes. On the prayer of the learned counsel for both the parties, list the case on 28/11, not 20.
10.
On prayer of counsel for both the parties, list the case on 28/10/2024.
Item 24.
Item 24, my lord, there is delay of 150 days.
Again, same case, but nobody has appeared.
Yes, same case, nobody has appeared.
That Malayalam set here.
Malayalam.
Issue notice on the question of condemnation of delay, returnable within 4 weeks, comma, requisites for which shall be filed by 25/10/2024. List the case on 18.
45th.
25th. No, that was a different matter.
18.
I kept it. 18/11/2020.
Item 25.
Disposal of at the stage of admission, the society has appeal member 120 days delay.
509 days. Written.
509 days delay.
No, my lord.
I'll check. I may be mistaken. I'm just checking.
Well, that order was 22/12/2022, was filed on 17/5/2023.
Then I may be mistaken,
I
but
may-
that's. No, it says 509 or 569.
69.
Sorry, I'm mistaken. It's 569.
My lord, 569, no.
Uh,
My
date-
lord, only,
date of valid presentation. The day you file the certified copy, they've calculated
Certificate, that is
accordingly.
the defect, that is, I have filed and it was filed on the,
Yeah, that is
last
why
month.
they've calculated
but
accordingly.
the writ appeal was filed just after 4 months.
Issue notice, there is a defect, 4B. Oh, a small defect, rupees 2.25 paisa.
Let I, course of
Mr.
today.
K.C. Sahu, learned counsel for the appellant, to remove defect number 4B pointed out with the stamp reporter in course of the day. Full stop. Issue notice to the sole respondent on the question of condonation of delay. Nahi, ta agura utte lekhantu. Mr. K.C. Sahu, learned counsel submits, learned counsel for the appellant submits that there is a delay of
120 days.
120 days in filing the writ appeal. But in view of the fact that the certified copy of the impugned order was filed on 13/8/2024, the stamp reporter has indicated a delay of 560. List the issue notice on the question of condonation of delay to the sole respondent, returnable within 4 weeks, comma, requisites for which shall be filed by 25/10/2024. List the case on 25/11/2024.
Other two opposite, the pro forma respondent.
Then why are you, I'm asking sole respondent, you are saying a
That
respondent number 1. Performer is who?
the government, registered cooperative society and assistant registered cooperative
Acha,
society.
acha. Issue notice, khali likhe hue. Don't write sole respondent. Issue notice. Requisites for service of requisites for issue of notice on respondent within 3 days, within so and so. Extra copies of the writ application, writ appeal will be served on the learned state council within the same date. Sub list on so and so.
Oh, bless you.
Item 26.
In item 26, 180 days delay and similar matter is fixed to 11th November.
No, but what is this?
Well-
What is this matter?
That regarding the pension of block grant,
11th is, that means.
11th November matter has been a batch of around 600, 700 matters.
All right. Yeah. IA 4377 of 2023. This IA has been filed for dispensing with filing of certified copy of Annexure 1.
Well-
Annexure 1, though? Annexure 1, full stop, for the reasons stated in the IA, comma, prayer for dispensing with filing of certified copy is allowed, the IA is accordingly disposed of. IA 4378 of 2023, sole respondent or others are there? To the sole respondent on the question of condonation of delay, returnable within 3 weeks, requisites for which shall be filed. Please file the requisites early.
Well-
Shall be filed by 23/10/2024. List the case on 11/11/2024 along with connected matters. Pujandi?
It's 2949. That batch. Batch of matters. WA number 2949 of
Yes.
2021, 23.
23.
Number
WA 2949 of 2020.
connected matters, WA 2949 of 2023 and batch.
Item 27.
Item 27, my learned friend appears there is 108 days delay. I can serve a copy mail if you permits me.
Yes,
And it may be also fixed to 11th, similar to that.
similar, that same.
Same.
Okay. IA 4416 of 2023, allowed. Dispensing and filing is allowed. IA 4417 of 2023, full stop. Mr. P.K. Behra has appeared. Giving notice, Mr. P.K. Behra, Learned Counsel, has appeared on behalf of the respondent number 1. Copy of the IA for condonation of delay shall be, Mr. M.K. Pundia, Learned Additional Government Advocate, undertakes to have a copy of the IA for condemnation of delay on Mr. Behra. Aji, you'll give it today or
I'll serve to, in course of the day.
in course of the day? List the case on 24. Sorry, list the case on
11/11.
only 8 days. List on 24/10/2024 for orders.
11/11, madam.
Why 11/11? You don't want the delay to be condoned?
Oh, yes, madam. I'll, yes, ma'am. Yes.
Where is the copy? What is the delay?
180 days delay.
What is your submission? No.
No, definitely.
No objection.
No.
Okay, no need to serve copy also then.
Sir, copy of the
Copy?
writ appeal.
Copy of the IA is okay.
And also writ appeal I'll serve.
Okay, okay. Mr. P.K. Behra, learned counsel has appeared on behalf of the sole respondent. He has no objection. Prayer for condonation of delay. The IA is accordingly allowed. Copy of the writ appeal is served on Mr. Behra by tomorrow. List the case on 11/11/2024 along with the connected matters. WA 2949 of 2023 and batch.
Item 28.
25 days.
25 days.
Yes.
So no private parties?
Yes, sir. Private party respondent 4.
Is there?
4 is private.
Not. Oh, otherwise you would have condoned the delay. What is this matter?
The order of the collector has been challenged. And at the
Anganwadi.
learned single judge.
Anganwadi.
Yes.
What is wrong with the order?
Without giving any reason, the learned single has accepted the order of the collector and dismissed. And they have already directed to approach the collector once again. When the collector's order has been challenged.
Oh. No, but they say there is no illegality in the order. But says if you have any inconvenience in traveling, you may approach the collector for considering your grievance.
That was the collectors passed the order without considering the report of the CDPO. And that order was challenged before the learned single judge. The learned single judge has dismissed, and we have not given reason, only recording the submissions that are the why that has not been considered, the report of has not been taken into consideration, that has not been, anything has not been discussed.
Okay. You notice on the question of condonation of delay, full stop. Requisites for issue of notice on respondent number 4
Yes. Respondent 4.
by registered post, speed post, returnable, speed post, registered post with AD shall be filed by 25/10/2024. Notice shall be made returnable within 4 weeks. Full stop. The writ appeal shall be served. Name Mr. Who? Mr. Samantre?
No.
Who will accept notice?
I can explain because
Mr. Samantre, learned additional government advocate, accept notice on behalf of respondents number 1 to 3. Copies of the writ appeal be served on him by 25/10/2024. List the case on 25/11/2024.
Item 29.
There is a delay of 74 days. And then
I filed my objection, my lord. In this case, the impugn order, your lordship may see para 5. That is,
Objection is not there on record.
well, I'm filing today, my lord. On the last occasion,
No, but it's just a question of condonation of delay.
yes, my lord. That's what I want to say, my lord. It's a family pension, 81 years old lady. Here, what has happened, relying upon a particular judgment, which is squarely covered in my case.
We can dismiss the writ appeal. We can ensure that you are paid what you are entitled to. But why should we not condone the delay?
Because no sufficient cause has been shown.
All right.
One,
Then you can argue.
my lord, your lordship may see.
Then you can argue on
Yes,
on
ma'am.
point
Yes.
of limitation only.
Yes, yes. The order was passed on so.
Mr.
Yes,
Your client is 81 years old.
yes, my lord.
You want payment of post-retirement benefits to her.
Family pension, yes.
It is always advisable not to enter into such issues. We will ensure that what she is entitled to, she will be paid. Otherwise, if you desire, you want an order on the point of limitation, we will give that. And
Yes.
the writ appeal shall remain pending in that case. As you wish.
Because if we find that the order is not sustainable, we will definitely interfere with that.
Right, right.
So whatever the delay. But if your case has merit, we may condone the delay, but dismiss the writ.
The other writ appeal has already been dismissed.
So that only we can consider after the IA is disposed of.
Your lordship may just see that what is the limit cause they have given, my lord. The order was passed in the open court on 16/8. This, and I have submitted the copy on 24/8, 25/8, and 6/9. On 3 dates, I have supplied the copy. They say that we have received it on 13/11. 3 months, more than 3 months period. Well, it's from Berhampur to Bhubaneswar that has gone by postal, by registered post and all. And then they say no steps have been taken within the period. But I have averred in my affidavit. There have been discussions, there have been correspondence.
We will not. Are you control? Good or not?
No, only
Application has been filed for continuation of delay of so 84 days.
74 days.
74 days in preferring the present Court of Appeal on behalf of the state of Orissa. When the council hearing on behalf of the respondent has vehemently opposed this application seeking continuation of delay. Stop. However, considering the facts and circumstances and the period of delay, we are of the opinion that the case is made out for continuation of delay. This application is accordingly allowed. Issue notice WA. Yes.
I'll take notice, my lord. Your lordship.
Accept notice.
Let them serve copy of the written. I am filing my objection along with memo of citation. That may kindly be kept in record.
Yes, that is there. File the
Registry.
Item 30.
30 minutes. I have entered appearance on behalf of the respondent, my lord. Sole respondent. See, I have entered appearance for the sole respondent, my lord, in this appeal.
30.
And similar matters have been dismissed by my lordships. I am providing the judgment copies after being confirmed by the Honorable Apex Court, my lord.
So what should we do?
Writ appeal has been dismissed, my lord.
368 days.
So we can condone the delay and dismiss your appeal.
Right.
If there is any merit.
Similar matters have been rest, my lord.
Give him a copy of that order.
My lord, I'm providing.
No,
Sorry?
Last time
tomorrow.
Your lordship may
supplied the
condone the
copy.
delay and keep it to tomorrow so that I can argue on merits.
All right. So it will come tomorrow. This is
I'll also go through the order where which my learned friend is referring to.
all right.
If at all
Last time I had provided the copy, my lord.
So
Last-
both the matters will come tomorrow.
both the
All right. You argue on limitation and main matter
as well as
Fine.
yes. Fine.
Fine.
in the light of this order.
Fine.
On prayer of both the parties, list the case tomorrow. No, Mr. D.N. Mishra,
My lord.
learned counsel, you appeared or will appear?
I've already appeared online, my lord. I filed the buckler, my lord.
When?
Online today, my lord.
Today. Mr. D.N. Mishra, learned counsel submits that he has already entered appearance on behalf of the sole respondent.
My lord, sole respondent.
Sole respondent today. On prayer of the counsel for both sides, list the case tomorrow.
Item 31.
Along with Chaba, both the matters you've entered appearance, only one.
No, my lord, one, my lord.
So item number, so the second one, nobody has appeared.
No.
Okay, we can consider that tomorrow. So along with WA 448 of 2024.
Item 31.
Item number 31, I seek for an adjournment as the conducting counsel is unwell, my lords.
31 is about what?
The 31 has come in under orders, my lord. There is an IA which has already become infructuous.
Already?
Become infructuous, my lords. IA has become infructuous.
IA has become infructuous.
Yes, my lords. The IA was filed, my lords, for but the examination which was to be conducted at that point of time was
This is a writ petition. Stay the operation of the examination.
Yes, ma'am.
Okay. Okay. All right. What is your name, please?
it was Aditya Narayan Das.
Aditya Narayan Das. Who's going to argue the matter? Because
Saurav Gua Thakurta.
Acha, Mr. N. Das, Learned Counsel, submit at praise for an adjournment on behalf of Mr. Saurav Guha Thakurta. Full stop. List the case on 11/11/2024.
Orders matter. Matters under specially urgent matter, item number 2.
Item 2, may I pray this matter can be taken up after lunch? Last occasion, I have taken time to take instruction whether this matter is covered or not. That officer is coming. If your lordship may take up this matter after lunch or tomorrow, my lordship.
Tomorrow?
Item number 3.
Your lordship, this is a matter, tender matter, an application on relating to illegal and arbitrary action of the opposite parties. Number 1, issue of the supply order of the second agreement. Number 2, for the payment towards the overdues of the first agreement. And number
First one.
There was first agreement.
first agreement was payment.
First agreement, what is the date of the first agreement?
Seven 4/2021.
7/4/2021.
Yes.
What is your grievance relating to first agreement?
The first agreement, in first agreement, they are stopped from my payment, overdues payment not paying, and postponed the supply order also.
Payment not made,
Yes.
supply is postponed.
Yes, for until further correspondence, supply order was postponed.
So this is first agreement.
Yes, sir.
And what is the second agreement?
Second agreement was signed on 26/2022.
Yes.
In second agreement, their clause is that in 12 clause, the supply order will be issued and the agreement will be valid till the 2 years of this issue. Till now, they are not issuing supply order,
Supply orders are being
not issued till today.
not issued. So what was the agreement?
Yes, sir.
What was the agreement? What was the period of agreement?
The period of agreement is 2 years, valid 2 years from issue of the supply order,
So whenever they issue supply orders, that will be valid for.
valid for 2 years.
If they issue it that today, that will be valid for.
But they are not issuing the supply order, that is matter.
Means it's a lifetime agreement.
Lordship, already lifetime agreement, but these stocks are the live stocks we have to supply. These are B colony.
Yes.
After the agreement, already we have deposited the performance security and already we have started the production because anytime they will give the order
Very.
to supply. Anytime we have to keep ready all the things. So we have already invested all the things in pipeline, all the things, but the supply is not
First
coming.
agreement, second agreement, and then
These 2 agreements.
there are 2 agreements.
Yes.
And you have filed 1 writ petition.
1 writ petition and 2 IA.
Mr. Naik,
It is difficult.
Mr. Naik, I think the agreement says 1 year.
First agreement is valid.
1 year.
Lordship, there are 2 agreements, 2 tenders, but from one competent authority in one project.
Sir, counsel, you are not a counsel, sorry. Mr. What is your name?
Naik, Mr.
Naik.
Naik.
Mr. Nayak, you cannot maintain 1 writ petition. There are 2 separate cause of action. That you will have to understand.
The cause of action is same.
Cause of action is not the same. Cause of action is different because there are 2 separate agreements based on 2 different tender processes. So you just decide which agreement you will press in the present application, in the present proceeding.
Your Lordship, actually, the two agreement from two
There is no
different.
question of actually. The question of there are two agreements, two tender processes. Therefore, if you are aggrieved, you will have to prefer two separate writ applications.
Then first agreement. Then
First
first agreement.
So let us forget second. Application. The owner has raised grievances relating to two agreements between the company,
Naik Associates.
Company or firm?
Proprietor firm.
Proprietor.
between agreement between the petitioner and who is the agreement between you and
Collector Sundargarh.
Collector Sundargarh. Dated 7/4/2021 and 26/2021.
Yes.
So it is an admitted position that the two agreements were entered into between the petitioner and the collector based on different tender processes, two different tender processes. First off, Mr. Nair, the petitioner in person, has submitted that in the present application, he shall confine his grievance relating to the first agreement, that is 7/4/2021, with a liberty to file a separate writ application in respect of the other agreement, that is 26/2020. 26/2022.
26 July 2022.
Why have you given two MOUs for 2022 respect of different articles?
No, madam, that is the matter is one tender. But the competent authority separate for the two persons, DICGM and DIC, to do the different item procurement. But the project is one, mega apiculture. Procurement authority is two.
Okay.
For the present, we are not.
So you examine for the second lot whether you'll file two or three, one or two. Okay, we are not entertaining that, so we are not saying anything, but you examine while filing the second one.
In survey of the matter. We permit to confine the present application. His grievance relating to the agreement dated 7/4/2021 with a liberty in relation to the second agreement as sought for.
Agreements dated 26.
Yes. So what happened? Let us understand what was the tender, what was the agreement?
Lordship, in 2020, the meeting was held by under Principal Secretary to Government.
What was the tender about?
About the mega apiculture beekeeping.
Mega
Apiculture.
apiculture.
Sir.
Yes. Then
DICGM had floated the tender. I had participated in tender. DICGM, General Manager DIC.
DICGM is Latin for me. What is the meaning of DICGM?
District Industries Center.
Yes.
General Manager District
Industry Center.
What is the full form of DICGM?
District Industry Center.
And GM?
General Manager.
General Manager.
Yes. So what was the tender about?
Tender about the supply of beekeeping materials.
Supply of beekeeping.
Yes.
Yes.
The supply of livestock and bee boxes.
Yes. Then what happened?
After the agreement, I had supplied the 100% item to the opposite one, got 100% payment. But in the case of the opposite party number 2, I had supplied 75% goods before.
What is opposite party number 1?
Opposite party number 1 is District Industry Center, General Manager, District Industry Center, Sundargarh.
And who is opposite party number 2?
General Manager, Regional Industry Center, Rourkela.
So Rourkela is not paying.
Rourkela is not paying and also postponed the supply order
Postpone the supply order.
until further correspondence.
Mr. Naik, so first there were again two agreements, that means.
Yes.
2 agreements then.
In tender, there is one tender for 2 agreements always.
Yes, Mr. But again, there are 2 agreements
Let us see.
for the first the thing tender process also.
First,
Whether in the same agreement, the district of Sundargarh and Rourkela are mentioned
yes,
in one agreement.
first agreement mentioned.
In one agreement or 2
Two
agreements?
agreement, both all different 2 agreements.
First they have paid.
First they have paid.
First already paid, clear.
All right. It's in relation to Rourkela only.
Rourkela.
Yes.
It-
Yes, Mr. Have you filed your affidavit?
Lordship, no, this is first time, Lordship, kindly page 64.
Open.
Page 64, my lord.
Yes, yes.
This is a tender call notice, my lord. Page 64, my lord.
Annexure?
Annexure 4, that is a part of the page 64, my lord. 64.
Just a minute. Yes.
My lord, this is a quotation call notice from the general manager RIC Rourkela. Lordship, kindly see the first paragraph. Sealed quotations are invited in plain paper from the registered company firms of the state of Odisha and other states for supply of Apis Serna bee colonies of the beekeeping training in the different block of Sundargarh district for the year 2020-21 and 2021-22 as per specification. But that period is over, man.
He's asking for payment. Oh, he's saying you have not placed orders.
My lord, his allegation is that to supply the orders, my lord. Lordship, can you see the prayer?
Lordship, in page
Just a
1,
minute, just a minute. We'll give you time. When was that postponed?
postponed was in September 2024.
September 2024. Yes. So how were you supplying before September 2024?
Yes. The Lordship, before the expiry of first agreement, Collector Sundargarh renewed the agreement.
Was there any provision for renewal?
Yes, in tender there is a provision, clause number 2.2, if collector need, then they can renew the agreement. As per the renew agreement, and in the agreement clearly they mention in page number 24, if Lordship please see clause number 15.
Page?
124 of the petition.
Yes, what is there?
The call 15. May I read, Lordship?
This is the second agreement.
The second agreement is
So
put
this
that
we are not second agreement. is not
the
done.
stock those were not supplied in between the first agreement, before the expiry of the first agreement, the second agreement came before 10 days. So in second agreement, they mentioned that the rest P colony will
Sir,
supply.
Council, the first agreement was on the basis of a tender process.
Sir.
Whether the second agreement was on the basis of another tender process?
No, same tender process. No another tender.
So that, was there any stipulation in the it can be extended?
There is no stipulation, but there is a clause in tender that your Lordship please see in page 41 in tender call notice, period of contract. Period of contract. under normal circumstances, the contract shall be valid for a period of 1 year from the date of issue of work order. However, contract may be renewed for further period upon mutual consent of both parties on existing terms and conditions. It will be decided by the authority to extend it or not. Authority decided and they extend the agreement.
Well,
So the first portion confining it to one, we are not doing it. If after later we might pass that order. All right. So the first order which we pass saying that it is confined to the first MOU, we are not passing that order.
So you are not clear about your own case. We under impression that there were two tender processes. One for the year, this year 2021-22 and thereafter 22 anything.
Lordship, there is two tender process, but two tender in 2021. Because the project is mega agriculture, there are 5 products to supply.
All right, file your affidavit.
well,
6 weeks. So, we'll talk.
Twenty-five 11.
Yes.
second December.
Second.
Let them file affidavit.
Test admission item number 4.
May I please the lordship? The appellant is a PWD candidate. She is challenging Annexure 2 at page 99. The impugn order passed by the Honorable Single Judge. The background of the case is that present appellant, being a PWD candidate, offered her candidature for the post of regular teacher for government secondary school under the PWD category. If your lordship will come to page number 34, it is a breakup of all the categories of PWD for what post which will be reserved for PWD candidates. I have applied for the post of Hindi teacher under the
No, this is which item?
item 4, your lordship.
WA 2048.
Yes.
My lords,
Yes.
I am challenging Annexure 2 passed by the Honorable Single Judge,
Yes.
ordered 20th June 2024,
Yes.
whereunder my application has been dismissed.
Yes.
Can I give the background, your lordship? The back.
Just come to the order and tell us how the
My
order
lords.
is incorrect.
Page 101. It starts with page 101.
Yes.
Paragraph number 3. Pursuant to the order passed by this court on 25/2024, learned additional government advocate produced the report submitted by the Regional Institute and Department of Ophthalmology, SCB Medical College and Hospital, Cuttack, Odisha and Court. The same be kept in record. This court, after going through the said report, finds that disability of the petitioner has now been found at 30% temporary, since the minimum requirement to get the benefit of appointment is 40% permanent. In view also produced before this court today, this court is not inclined to entertain the prayer as made in the petition and dismiss the same. My entire case is, your lordship, I have offered my candidature under the PWD category. The competent authority under the Central Act, that is the RPWD Act 2016, has issued a certificate of 40% permanent. If your lordship will kindly peruse my certificate, I have enclosed that. That is at page number 57, your lordship. Department of Empowerment of
No,
Persons.
but why was a report called for from SCB?
That is exactly my case, your lordship, because I specifically raised the case before the Honorable Single Judge that when a competent authority has issued a certificate, the appointing authority cannot tinker with my disability percentage.
That can be done. If something is issued fraudulently, then of course the jurisdiction or can go into that aspect. Yes, what is this? What is the certificate?
Yes, your lordship, page 57.
Yes.
It has been issued by the Medical Authority in Nayagarh under the RPWD Act. By the competent authority.
Yes.
Undoubtedly. On that basis, I made my application. Now, I have undergone the written examination of both preliminary and main.
No, forget. This
My
is
lord.
your certificate.
My lords.
And the certificate has this, the authenticity of the certificate has been doubted by the learned single judge.
Not doubted, your lordship. Under Annexure 8, I have challenged. Honorable single judge at page 77, I have challenged. That is the order. At page 77, the appointing authority has decreed my percentage from 40 to 30, but my disability has been affirmed. There is no doubt that I am disabled. I am
Mr.
disabled.
Biswal,
My lords.
you had filed the writ application. Why? Because that you were not given appointment.
My lords.
So why were you not given appointment?
Because my percentage after appointing authority, after reassessing my disability, they have come to a conclusion that my percentage has been reduced from 40 to 30%.
Yes.
Just think of an extreme situation where the disability certificate shows that you don't have the other leg, left leg. All right, this is the certificate you are having.
My lords.
The court directs that just find out whether he has both the legs or not. And if the certificate, if the on examination it comes that he is fine, can you rely on a certificate? And can the court decide because you have a disability certificate issued by a medical officer, therefore medical authority Nagar?
In fact, that
When did you file your that means?
when did you obtain it? The one in which you rely on?
It was on 9, your lordship.
2009.
When did you apply?
Applied.
2022.
2022.
So that way it has improved. Your eyesight has improved. That is why from 40 it has gone to 30.
The peculiarity of the case is, your lordship, I have been before the competent authority thrice. Once in 2009, they have said 40% permanent. In 2024, they said 30% permanent, from 40 to 30% permanent. Now, the Honorable Single Judge again ordered me to appear before another medical board. He says 30% temporary. My submission is, if you will again another medical board, he will also say that there is some other percentage of disability. The disability varies with person to person, your lordship.
All right.
You mean to say it depends on the person examining?
Yes, that is already happened, your lordship.
There is no fixed standard.
No, your lordship. That has happened in this case because 2009 40% permanent, 2024 30% permanent. Now another medical board said 2024.
No, just a minute. 40%, then it becomes 30%.
Permanent.
But
The
if
appointing authority.
40% has become 30%, it was never permanent.
Permanent, your lordship, because at page 77.
How did it improve to 30%?
Improved with 10%. But
His submission is that based on the examiners, the report may vary. And because the competent authority had issued certificate in 2009, then that is the binding on everyone. This is your submission.
My lord.
Rejected.
But your lordship, kindly just appreciate the fact the percentage of a disability is varying from person to person, because with the operating authority under annexure page 77, they have given 30% permanent. Now another board says it's 30% temporary now. So when it becomes temporary, then my lordship, the certificate is issued by the competent authority under the RPWD Act. It become a piece of paper. For any other appointment, I cannot be eligible for appointment, even though I am a disabled person.
No, you are a disabled person. Nobody is doubting.
My lord.
Because you have some problem with your eyesight.
Yes,
but the percentage which entitles entitles you to a job,
my lord.
that is under consideration.
But your lordship, the two boards have been constituted. They both have tinkered with my disability. One says permanent, one says temporary, which has to be followed, your lordship. That's the question I'm asking to myself. Sorry. Now, for all now this certificate is issued 2009. It is a piece of paper. I can't rely on that.
It is a piece of paper. It's a piece of paper. And do you want us to direct for an inquiry? It's a fraudulently obtained certificate, Mr. Counsel.
My lordship.
And another thing, Mr. Biswal, you have yourself agreed for that examination. You have deposited cost of 1,000 You've not agreed? Have
I've
you
not
challenged
agreed.
that order?
Because your lordship, the
Learned
single
counsel for
judge-
the petitioner fairly contended that because of the wrong committed by him, petitioner could not appear on 16/5/2024. It is contended that if some other date will be fixed, petitioner will appear in terms of before the board in terms of the order dated 9/5/2024. Considering the submission, you are permitted to appear subject to deposit of cost of rupees 1,000.
I have agreed because the delay was caused because I've taken instruction from the petitioner whether he
Yes.
will appear before the medical board or should I challenge this order. He said, I will,
Alright.
she fairly said that I need the appointment, I will appear before the medical board. I will take my chance. She appeared. Now
So
considering
now you challenging that.
my lord, you 30 temporary now. That is my submission. My
So
lord,
have you challenged that certificate?
my lord,
Have you challenged that certificate?
which certificate, your lordship?
In which- For the examination?
That was not never supplied to me. That was never supplied to me. It was before between the state and the honorable single judge.
Fraudulently obtained certificates and relying on.
Lordship, I will beg to differ, humbly beg to differ. It's not fraudulent because both the medical boards found that I am disabled. The percentage is now in dispute.
Nobody is disputing that you're disabled, but you will get a job only depending on the percentage of disability. That we have to rely on the examiner.
And more importantly, the resolution on
Neither
the
can,
case.
neither does your opinion matter, nor does our
Mine
opinion
does.
matter, because it is the experts who have given you
I
the
humbly bow down.
certificate.
I humbly bow down. But my submission is will vary from person to person. It is varying.
May
Permanent
vary,
becomes temporary.
may vary, but they are the experts. And the board was constituted in your case.
And most importantly, your lordship, they have done this examination of my disability by virtue of page 78. This is a resolution which permits for that assessment of disability. Page 78, your lordship. At
Who
page
is the-
79,
Just a minute.
my lords.
Who is the competent authority? Who had given you the certificate?
Issuing medical authority, Nayagarh.
Medical-
CDM,
Huh?
Chief District Medical Officer.
Oh. The petition, the appellant in the present appeal has put to challenge. Court appeal has put to challenge an order dated 26/2024 passed by a learned single judge of this court in WPC number 11547 of 2024. First off, the appellant claimed to be a PWD candidate for appointment as a regular teacher for government secondary schools under the control of School and Mass Education Department. First off, she relied on a medical certificate issued by the SEPD department.
My lords. Department of Empowerment of Persons with Disabilities.
Just where is your certificate?
Page 57, your lordship.
Certificate dated 1/12/2009.
My lords.
Relying on uh, a disability certificate issued by the Medical Authority, Nayagarh, Odisha. First off, according to the said certificate, the petitioner had 40% permanent disability in relation to
Left eye.
her left eye. First off, the process of the selection in question had begun in 2021.
22.
First off,
And the merit list was published on 2020.
just a minute. Why did that decline?
My lords,
Why did they decline?
I'd be 77 because I have 30% permanent disability.
No, basing on the SSEPD department resolution.
My lords. It's at page number 78.
But where did that 30% come when you have given a certificate for 40%?
They have reassessed, your lordship.
So they also reassessed.
They said 30% permanent.
So that was as per the resolution.
Where is that? Where is that? 30%.
At, my lords, page 77.
They reassessed as per annexure 3, your lordship.
Mister, you will have to initiate
sorry.
action, disciplinary action against the person who had given the first certificate. We are directing the additional chief secretary health. Who is he?
Additional chief secretary.
He will have to inquire into
Commissioner
and if required, he will have to initiate disciplinary action. Because of that certificate, the litigation has been generated unnecessary. And all such certificates which have been issued by him. Kalika, which page?
At page 77, your lordship. CL number 2. Appellant's name.
For the purpose of the set selection, the petitioner was made to, for the purpose of set selection, verification of genuineness of nature and degree of disability of selected candidates under PWD reservation category was done.
As per the resolution.
As per the resolution
Number 1843 dated 25/2/2021
My lords.
of the SSEPD department.
the said verification, the percentage of disability of the appellant was found to be 30% in the nature of 30% bracketed permanent. Stop. As the 40% as minimum of 40% of disability would have qualified the petitioner for her appointment as PWD candidate, she was declined the appointment. The petitioner, the appellant, accordingly filed the writ petition asserting writ petition, that is
Yes.
WPC number 11547 of 2023, asserting 24, asserting that it was impermissible for the authority to verify the genuineness of the certificate which was issued in 2009 by the competent authority.
That was not my submission. I said they can verify the genuineness of the disability, but they can't tinker with the percentage of disability issued by the competent authority.
So tell what was your submission? And I'm not.
I beg apology.
Please.
For your exact submission, what is
Exact submission.
My submission is
Please
that
dictate.
that writ petition
Please do it.
challenge.
Please do it. Please do, Mr. Counsel. Please do. Please make one sentence. Just say. Just say.
I beg apology, Your Lord.
Please, Mr. Counsel, otherwise we will again commit mistake.
I beg apology. I will not interrupt. Your
Please
Lord.
do it.
Mr. Vishwal, I'm finding you becoming emotional in court. Why don't you conduct your case? Why are you getting emotional?
Say.
Please say what your submission is. It will be noted down. You have challenged the rejection of your candidature on what ground?
On the ground that the disability certificate has been issued by a competent authority, they can check my genuineness of my disability, but they cannot tinker with the disability percentage which has been issued by a competent authority under the Act.
But for checking, they have to do that.
This is submission. It appears that that in order to resolve the dispute, as regards the petitioner's disability, the learned single judge passed the following order on 9/5/2024. First off, the petitioner the appellant was accordingly examined by a medical board of SCB Medical College, Cuttack. Board, it was a medical board,
Yes.
team of doctors. So the appellant's disability, why it should not be
No, this date was fixed because they could not comply.
subsequently another order was passed by the learned single judge on 25/2024, paragraph 4 of which reads thus. Pursuant to the said order, the appellant was subjected to examination by a board of doctors in SCB. The said board has found the petitioner's disability to be 30% instead of 40% of temporary nature. Stop. Next. Learned counsel appearing on behalf of the appellant has submitted that the authorities ought to have acted upon the certificate which was issued by disability certificate which was issued by the authority in 2009, which clearly mentioned that the nature of disability was permanent.
And 40%.
Permanent and 40%. First off, he submits that during the verification, the disability was found to be 30% of permanent nature. First off, now the team, medical board of SCB has found disability 30% disability, but of temporary nature. First off, he has accordingly submitted that if any fresh verification is done, fresh re-examination is done, the disability percentage and the nature of disability may vary. First off, he has accordingly submitted that instead of relying on the report based on verification, instead of relying on verification report or the report of the medical board of the SCB, comma, the authorities ought to have relied on the original certificate which was issued by competent authority in 2009. Stop. Next. We are of the prima facie view that it is mainly of the original certificate which was issued by the medical officer Sundargarh Nayagarh that has generated litigation. Full stop. Generated this litigation. Full stop. Before entering into the merits of the present intra-court appeal, we are inclined to direct the Additional Chief Secretary,
Commissioner
Secretary, Health Department, Government of Bihar, to Government of Odisha to we are inclined to direct in the interest of justice the Commissioner cum Health Secretary, Government of Odisha, to cause an inquiry as to which the certificate was issued by the competent authority in 2009, which has been found to be incorrect subsequently during the verification, and later by a team of doctors of a reputed medical college of the state, that is SCB. They will also examine as to whether the said competent authority, competent in the, what is that, hospital or?
Nayagarh Hospital.
Nayagarh had issued similar certificates which were subsequently not found to be genuine. First off, if that be so, comma, the commissioner shall take a decision as to whether a disciplinary action is required against the person issuing PWD certificates or not. List this appeal on 8 weeks.
With your lordship's kind permission. acceptance, let her also be re-examined from that medical board because they are already conducting.
No, we can do it subsequently.
What are you saying?
Let me re-examine again.
Huh?
But that defeats your submission.
Maybe
You
your
say
lordship,
let
let
her
her
be
take a chance
re-examined
because
again.
otherwise she will be prejudiced.
We can consider that. We can consider that later.
Yes.
We can post it to a particular date and then.
6 weeks. In the meanwhile, the commissioner shall be required to file an affidavit as regards steps taken pursuant to this court's order. Unless he states, well, I'll not make it that. You want
We consider.
re-examination?
My lords.
Make that submission.
Yes, your lordship.
What?
Let her be re-examined by that board.
Are you sure you want to take some instructions and then make that submission?
Either way, your lordship, if the lordship is not getting appointment, let her be, there's some certain chances they will again reassess the disability.
Think
See, because of
calmly
her,
and then do it.
someone else may lose appointment, Mr. Counsel. Yes.
Item number 5.
Item 5 on behalf of Jan Kumar, I thought prefer an adjournment to get to tomorrow.
Two.
He had mentioned that.
All right.
Some other day.
When?
Get to tomorrow.
With your lordship.
Item number 6.
Sorry, I'm interrupting in between, but I have asked the appellant, she's ready to undergo another.
Next day we can pass that order next day if required. So you may.
Item 6.
May I please your lordships? The petitioners are two lawyers of Nabarangpur District Bar Association.
Lawyers of
Nabarangpur District, Miller.
which district?
Nabarangpur, Miller.
Naranpur.
Yes,
What happened?
What happened? There is the Sri Chaitanya Temple indexed under Endowment Commission, 100 years temple situated in Nabarangpur city, Miller. There is a teen house under the DTs that under a teen house for several years, Miller. But opposite party number 5 and 6, the private parties, the 4 is Tahsildar cum executive officer endowment for Nabarangpur city. The opposite party 5 is working under opposite party and he is the head clerk of Tahsil office. Unauthorizingly, they have constituted a committee and constructing the Kalyan Mandap for commercial purpose in the premises of that temple and also encroach some land.
So your twofold grievances is one is that Kalyan Mandap is being constructed and secondly they have encroached on the public road.
Yes, ma'am.
So who is doing?
My lord, opposite party number 5 and 6, they are private parties. Their committee is not authorized by the end of. And my lord, page 24.
Have you not approached the
Yes,
Endowment
ma'am. I have
Commissioner?
approached the collector, endowment commission, and collector has in 2013, my lord, they have called for a show cause from Kailas Chandra Das, the opposite party 5, unauthorized construction of new prayer hall in the premises of Sri Chaitanya Temple at Nabarangpur, page 21, my lord. It is come to the notice to the understand that you are unauthorizedly construct one new prayer hall in the premises of Sri Chaitanya Temple, Nabarangpur. Hence, you are hereby directed to submit the following regarding construction of new prayer hall in the said premises within 7 days from receipt of this letter. Whether you have obtained permission from concerned authority, whether you have any plan and estimate from proper quarter, whether you have obtained no objection certificate either from or executive officer come Tahsildar endowment Nabarangpur. And Miller.
Mr. Pradhan, I think the annexure 3,
yes.
the Tahsildar has directed for staying the construction until that inquiry is done.
My lord, the
That's so?
petitioners are appeared.
Yes.
The opposite party 4, 5, 6 and other committee members.
So then
And
we are super Tahsildars.
my lord.
Are we super Tahsildars?
But have they
No,
stopped?
my lord.
But the construction has stopped.
Yes, construction is going on, my lord. That's why, my lord. And they have also made
Tahsildar is there.
representation before the collector also.
Why representation? When the Tahsildar is there, then why?
No, my lord, my annexer 2 series, 25, phase 25, my lord, to Dr. Kamal Lochan Misra IS, the Honorable Collector and District Magistrate, Nabarangpur. They have made all.
5 years back.
Yes, my lord. No, my lord. That is on.
Your communications, annexure 1.
No, that is 27/5/2024, my lord. May 24, this year, my lord. After getting the this grievance petition, the collector directed to the Tahsildar to show cause, for show cause. The Tahsildar make a call for a show cause.
Why are you not taking recourse to the provisions under the Act? Why have you come to the High Court?
Lord, unauthorizedly they are constructing.
Unauthorizedly, so many things are being done unauthorizedly, even theft is not authorized.
If your lordship will issue notice the.
Why issue notice? Unless you have a case, unless you don't have any remedy, Why should the court interfere?
My lord, they have made the representation before the commission.
Where is it? The representation will not do. So what is the legal position? Who has the duty?
My lord, the
Have you examined?
yes, my lord, the opposite party 4 is the Tahsildar officer of endowment.
Endowment, so what power does he have?
My lord, unauthorized encroaching, he has called for a show cause, my lord, in page 29, annexure 3, my lord.
Yes.
But they have not appeared.
They have not appeared.
No, the
So
petitioner.
therefore, we should direct him to appear.
No, my lord, I am not saying that. The petitioner appeared, but the opposite parties, those who are constructing, they are not appeared. But till that, they are constructing the over the land. But no remedies are taking opposite party number 4.
Every dispute is to be decided by this court. Yes, madam. Why is this happening?
The endowment commission, your lordship, notice will go because Tahsildar is acting as per the endowment commission, your lordship. Notice has to go, your lordship.
You can get instruction from the Tahsildar also because there's a allegation of illegal encroachment also.
If your lordship says so, I can take, but otherwise it should be from the endowment.
File an affidavit, you will see. Let an affidavit be filed by Tahsildar, opposite part number?
Opposite party 4, my lord.
4, your lordship.
4. Dealing with the allegations made in the writ application. Top, the court will consider issuance of notice to the other opposite parties depending upon the stand which Tahsildar may take in its affidavit. In his yes.
One IA is there. IA is there
IA.
to stop construction.
Very good. Let him file.
Oblige me.
Item number 7.
Arbitrary rejection of the bid, the petitioner is being assailed before your lordship. That's your lordship may straightway come to page 175.
Yes.
Where my bid along with the bid of another tenderer was found to be responsive. Page 175, Annexure 3.
Yes.
After the technically I was qualified, the price bids were opened, and thereafter Annexure 5 at page 177 emanated. This is directed to the petitioner, issued to the petitioner with the reference to the above cited subject. Cited subject, I am directed to intimate that your quoted value of the aforesaid work amounting to so and so, less the amount put to tender, that is so and so. Hence, you are requested to furnish additional performance security amounting to so and so. Now, at this juncture, may I invite your lordship's attention to the conditions of the tender, which is at page clause 8, my lords, at page 28. 28. Has your lordship's got page 28?
Just annexure.
This is part of annexure 2, annexure 3, NIT and the DTCM.
Annexure 3 begins from
2 series.
Annexure 2.
Yeah. Page 28,
yes.
Clause 8, my lords.
Yeah.
May I read it out?
Yes.
Additional performance security shall be submitted by the bidder when the bid amount estimated cost put to tender. In such an event, only Clause 8, my lords. At page 28.
Yes.
Additional performance security shall be submitted by the bidder when the bid amount is less than the estimated cost put to tender. In such an event, only the successful bidder who has quoted less bid price rates then the estimated cost put to tender shall have to furnish an amount as stipulated towards additional performance security in the shape of bank draft in favor of so and so on a nationalized bank counter guaranteed by its local branch at Bhubaneswar 7 days of issue of letter of acceptance by Orissa Construction Corporation Limited. So 7 days, I lay emphasis on the word within 7 days of the issue of letter of acceptance. So my lords, I produce Annexure 5 to the bank for issuance of a bank guarantee. I treat Annexure 5 to be a letter of acceptance where I am called upon to produce additional performance security, and I produce it to the bank. The bank says that this letter is not a letter of acceptance, and hence I seek for time. You give me a letter of acceptance and give me some time, I will furnish the secure bank guarantee. They refuse to do that. Annexure 7, page 180. Page 181.
Yes.
With reference to subject cited so and so, to intimate that it is requested to furnish additional performance security of rupees 10 crores of issue so and so by as per DTCN clause 76 and clause 8, which I read out to your lordship of the above e-procurement notice. Your request for extension of time for another period of 1 month is not considerable as per the relevant clause of NIT and DTCN. Hence, your bid is liable for rejection as no APS has been received by this office till date. And thereafter, my lords, I bring it to their notice on the next page. If your lordship takes page 181. Seventh line into that letter. Seventh line into that letter, sentence beginning, treating this as LOA. We had approached our bank for issuance of necessary bank guarantee to that effect. But our banker has intimated us that it is not possible for issuance of bank guarantee in the absence of letter of acceptance. Whether Annexure 5 is a letter of acceptance or not, and if there is no letter of acceptance.
What is Annexure 6?
Price bid, my lords. Sorry, my lords. Yes, we had requested for time to give the furnish the APS. That's the additional performance.
Why?
Because we have to go to the bank and ask for it.
But they say 7 days.
7 days.
Yes.
Provided this, I had asked for 1 month time, it was open for them to refuse that 1 month time. But question is that there is no letter of acceptance. In the absence of a letter of acceptance, my lords, how do I give a bank guarantee? The bank does not give me a bank guarantee.
What is the date according to you of the?
There is no letter of acceptance. According to me, 18/9/24 is the letter.
18/9/24. When did you approach the bank?
I approach the bank immediately thereafter, and the bank gives me and 26/9 is.
Bank said that we need time. We'll do the pursue that, and then we issue this letter.
27/9, my lords. This is 19/9, 18/9. On 20th, I approach the bank. 24th, I give the letter.
20th, you approach the bank.
Bank. So 24th, I approach. I give the letter to the authority.
What do you say in your letter?
That give me time to give the APS.
Because
I am pursuing with the bank.
No.
Yes, my lords. Your lordship thereafter sees the letter dated 27/9.
Currently, we are facing some financial problems.
Financial problem, we have to get the bank guarantee, etc. So thereafter, your lordship takes the letter.
No question of bank guarantee mentioned anywhere.
No,
you have said that
may not have been happily worded, my lord. May not have been happily worded, but it is clear from letter dated 27, which is on the 9th day.
No, but how do you say that you could not get the bank guarantee and therefore you could not your
this is where we have pointed out Annexure 8. Annexure 8, my lords.
So your explanation in this 24/9/2024 is different.
24/9 it has not been very happily worded. I should have said that yes, I'm with the bank. The bank is is working on my bank guarantee. I should have indicated that. It is not happily worded. May have been very casually written, seeking some time. But
No, you are very that you are facing financial problems.
my lord, but that is clarified, my lords.
And you are
The
seeking
financial
1 month's time.
my lord, that is further clarified from 27/9.
You could have sought in this letter itself that we don't have the LOA or that LOA is not being.
I was treating that to be the LOA. I accept that to be an LOA. But the bank says this is not an LOA because the word LOA is not there in Annexure 5. The difficulty is that, my lord, if the authorities would have just indicated that this is the matter would have ended. The bank would have given me the bank guarantee. I would have furnished it immediately.
No, you did not say that. You did not tell them that it is because of this that you are not getting.
Annexure 8, my lords, I have told them. Annexure 8.
No, Annexure 8 is later. This is your 24.
Yes, my lord.
Just before, rather 1 week, on expiry of 1 week.
1 week,
From the date of-
just immediately thereafter. Immediately thereafter. The bank was, it's a bank guarantee for 10 crores plus. So the bank would also take some time to issue a bank guarantee to that effect, my lords.
No, you could have.
Yes, my lords, I do admit there has been my letter which was given on 26/9 was not very 24/9 was not very happily worded. It should have contained the particulars that I am with the bank. The bank is working on the bank guarantee. That I will furnish it within some time.
What is the stage of the work?
Now the price bids have been opened. I have they have returned my EMD. I have indicated day before yesterday they returned my EMD. Put in the best bid, my lords. And I'm ready to apply. And there is they are themselves, my lords.
Similar communications must have been issued to others also.
Sorry, my lord. No other. I am the successful. I am the successful bidder only.
As per the clause, the person who is L1, so then.
There were only 2 qualified bidders. And thereafter my price bid was accepted. And Annexure 5 was issued in my favor.
As per that clause,
Yes.
isn't it the letter of acceptance? Because only to the person who has quoted the lowest price, they will issue, ask for additional performance.
But I say I accept it into the letter of acceptance. The bank does not.
So the bank is to be blamed.
My
Not the employer.
My lord, letter of acceptance, your lordship knows it has to spell out that yes, your offer is accepted. Then once the offer is accepted, the contract is concluded, my lords. Here they don't say so in Annexure 5. If your lordship closely sees Annexure 5, it does not say that your offer is accepted. They say that you furnish the APS. And the format is there at page 57 and 58, the bank guarantee which I am to furnish. It is to be issued by the bank. The LOA number has to be indicated there. Now here, there is no LOA number.
57?
Page 57, your lordship. It takes. This is the bank guarantee which the DTCN requires. The format. Lordship takes the second line, wide letter of acceptance LOA number dash dated dash. Now, if your lordship now comes back to Annexure 5 at page 177, there is no LOA number.
No, and this cannot be LOA.
And that is exactly my case, my lords. In the absence of the LOA, how can they ask for a performance security?
No, you please come to this. clause 8
Yes, my lords.
at page 28.
Yes, yes, my lords.
So that explains the circumstance
Yes,
in which you are required to.
yes, yes, yes. And that is exactly the situation here. Because the price was 45 crores was the tender value.
Only if you complied with this, the LOA could have been issued.
No. It's the other way around. Other way around. Kindly see, my lords. Kindly see. Kindly see.
No, they're not. No, please. No, no.
To be given the performance security is to be first. And that is further clarified.
Just a minute.
Sorry. LOA is to come first and then the performance security comes.
They consider this to be an LOA. So that is why it's stated that since you have not submitted it.
They should have clarified that that letter is the LOA. That would have sufficed.
When will they clarify? After a lapse of 7 days?
When I wrote to them on, they could have clarified on that.
7 days was over it's by that time. So that letter is clarificatory that was the LOA and you have not paid.
Yes, state.
Odisha.
This is a corporation.
Corporation.
Statutory.
Do they have counsel here or?
No, they don't. They have a panel.
We are issuing notice.
Sorry, my lord.
We are issuing notice.
Yeah, your lordship may stay the further proceed.
Which proceeding? Therefore, we
No,
wanted to know.
not the proceedings, the tender process.
Tender. Therefore, we asked what is the present stage?
The present stage is that they have returned my EMD. That is where it is now.
That will be subject to final.
Yes, yes. Your lordship.
Clear that any of the opposite party final adjudication of the case. Yes.
Sorry.
Want to convey something?
No. Once your lordships have understood what I wanted to say,
Even then, he is your instructing counsel. If there's something to say,
We are seeking this affidavit to be on record.
File it in the.
Yes.
What is that affidavit?
that's the EMD has been returned.
Okay.
That was our post filing of the writ petition. So,
Item number 8.
may I again please your lordship? Well, it's here, my lords.
Yes.
I'll straightway take your lordships to annexure 4 at page 114. This is, my lords, the proceedings of the Technical Evaluation Committee meeting.
Yes.
Sir.
Yes.
Page 114, my lords. The proceedings of the Technical Evaluation Committee. I am seeking the disqualification, technical disqualification in this writ petition. 114, and if your lordship takes 117.
Annexure?
That same page, annexure 4, it begins at page 114
Yes.
It ends at page 117.
Yes.
Column number 12 relates to the petition amount. While all other bidders have been qualified, I have been disqualified. The bidder has not fulfilled the minimum eligibility criteria. As
Which
per
page you are reading?
Page 117.
Page 117. Yes.
Column number 12. That is the petitioner. The bidder has not fulfilled the minimum eligibility criteria as per clause 117 of DTCN and is disqualified.
Yes.
Now kindly take clause 117 at page 50.
Yes.
Even qualified criteria are met, the bidder can be disqualified for the following reasons if inquired by the department. A, making a false statement or declaration. B, past record of poor performance. C, past record of abandoning the work halfway, rescission of contract. D, past record of inordinate delay in completion of work. E, past history of litigation. Now, I have stated on affidavit that I do not come under A, B, C, D because I have got an impeccable record of completing all jobs which have been given to me in time. And completion certificates I have annexed. The only thing which goes against me is E, that is pre-history, past history of litigation. Now, your lordships, in another matter, has had the occasion, in the case of Rose Marta, to hold that litigations at the instance of the parties cannot be held against as a ground for disqualification. Besides that, what is the litigation that I am involved in? I was blacklisted. I challenged it before this honorable court. That blacklisting order was quashed, has been quashed by the honorable court. The state has gone up in SLP. SLP is pending, no stay is granted. Second matter, I am before your lordship in another matter where I am qualified. I have been but work order is not being issued. That is also another matter which is pending before your lordship. Your lordship had the occasion to hear that matter and had directed the state to file an affidavit indicating what orders are being passed. So this is how one is
standard requirement. Don't know.
Litigation should not be question of blacklisting or something, I can understand. Litigation can also be that give me the work order.
I will file a reply mail on which ground they have rejected. Disqualified, my lord, on the clause 107.
That is the only thing.
That's the only thing.
That's the only thing, then
I'll file an affidavit.
This past history of litigation means he cannot file come to the court in case of anything.
Oh, my lord and friend is submitting that.
So forget about past history. Look at that clause. Past history of litigation. What litigation?
Mr. Counsel, we may hold that if you have any such stipulation in your documents, that will amount to contempt of court.
No, I have.
You are restraining people from coming to court. They'll be scared of. That if they go to court, they will be disqualified because of this.
My lord.
So you take a policy decision on this.
My lord.
You decide the matter, but you'll have to take a policy decision. Otherwise, this is contemptuous.
My lord.
After your lordship judgment, it is contemptuous.
And this past history of litigation is very vague also. Specific something regarding blacklisting.
Yes, I can understand scurrilous litigation, abusing process of law.
Exactly.
Scurrilous litigations, abusing process of law. Yes, that can be a disqualification. But I come to court, my stand gets vindicated by the court, and that is held against me.
Yes.
Well, let the tender process not proceed any further because now the technical price bids will be opened now.
It is the petitioner's case, inter alia, that his technical bit been rejected by the technical bid evaluation committee.
By the technical bit.
By the technical bid evaluation committee, invoking clause 117 bracketed E of the DTCN, which, according to which, quote unquote, past history of litigation is one of the criteria for disqualifying a bidder. Stop. Next learn senior counsel appearing on behalf of the petitioner has argued that other than quote unquote past history of litigation, there is absolutely nothing against the petitioner to disqualify it. So stop.
Under clause 117.
Under clause 117.
Please mention E also.
E. E I have mentioned.
Yes.
117 bracketed E I have mentioned. Stop. The on division bench decision of this court in case of
Rosemata Technologies versus State of Orissa. Good.
We are prima facie satisfied with the submission advanced on behalf of the petitioner that mere past history of litigation cannot be a ground for disqualifying a bidder in the technical bid. So stop. Issue notice. 1 week. There is sufficient.
They have said only 117.
No, here I have recorded that he stated that there is no other.
Because they have not stated that it is 117E.
They have stated 117 only.
Yes.
I have stated on affidavit do not come under A to D. The only thing that can be held against me past history of
It
litigation
is your submission.
is
Also.
my
For accept notice. So list this matter on 3 weeks.
Well,
3 weeks. Within first 5 days. So, in the meanwhile, the opposite party is to proceed with the tender in question, that is tender process in question, that is just give the details.
that is in the prayer to the IA.
Item 9.
Subject to the leave of this court.
Item 9.
Yes.
May I please? In this writ application, in fact, first occasion I had traveled this honorable court lordship. First occasion I had approved this honorable court. On the stage of lordship filing a reply, non-acceptance of additional performance security on the ground that I have not submitted within 7 days as per the terms of the contract lordship. And my humble submission was before lordship state I come to page 232 of the brief. that is 19.3. Is 32, Lordship.
Yes.
Let's plus 3. I'm reading just for the tabular column, Lordship. Next paragraph. The applicable additional performance security APS in shape of term deposit receipt placed in favor of the divisional officer oblique bank guarantee in favor of divisional officer from any nationalized scheduled bank in India counter guaranteed by its local branch at Bhubaneswar is to be submitted within 7 days of issuance of letter of acceptance, that is allowed by the divisional officer by email to the successful bidder. Whether the bid successful bidder shall be cancelled. Further proceeding for the blacklisting shall be initiated against bidder as per the works department office memo number such and such. Then let's kindly come to page 54, Lordship. They have defined, Lordship, how it is served, Lordship, how it will qualify serving of 7 days, Lordship. That page 54, clause 22, 22.1, Lordship.
54.
54, Lordship, page 54.
Yes.
There is a notification of award and signing of agreement, Lordship, that is. Employer oblique engineer charge shall notify acceptance of the work prior to expiry of the validity period by cable, telex, and facemail or email confirmed by registered letter. This is the qualification they have made it, Lordship. If they're sending through email, it has to be confirmed by sending it registered letter, Lordship. But in this context, Lordship, during they have issued the LOI, Lordship, that is annexure. Lordship, can you come to annexure 6, that is on 27/6/2024, page 69.
What is the date?
27/6/2024.
Annexure?
Annexure 6, Lordship, page 69.
Yes.
The issued letter of Lordship, I'm reading only first paragraph, Lordship.
Yes.
With reference to the subject cited above and tendered rates of the above mentioned work, it is informed that the tender has been accepted by the additional chief engineer, Rengali Right Irrigation Circle, Chaudhar, by his letter number such, being 14.99% less than the estimated amount put to tender, as you are requested to attend this office within 7 days from the issue of the letter of execution agreement with following documents, Lordship. They have given, Lordship, within 7 days, I have to approach before them with, and Lordship, this APS includes the item number, serial number 4. But at the relevant time, Lordship, in fact, I was suffering from dengue and I was in medical, Lordship. I could not, Lordship, accept that email. Then, Lordship, kindly, they have, Lordship, there is expansion, Lordship. Because it has to be confirmed by registered post. Had it been a case, Lordship, they could have been sent it with, I could have been obtained, Lordship. If at all I was not in home, Lordship, my family members could have been received the letter of acceptance. But I was admitted in the hospital, Lordship. So only they are saying, Lordship, they only send it through email. So I have not received, Lordship. So immediately, Lordship, I will come to annexure 6, annexure 7, page 71. Immediately, Lordship, I responded on 6th July, Lordship. And immediately I have made all the APS because at the relevant time, I was, Lordship, not in hospital, I was released from hospital. And immediately I have made the APS and I have for the authority, Lordship. And that decision was, because they have not taken that decision, I had approved with Honorable Court. And your Lordship, I had to take that decision, Lordship. And they have taken decision, Lordship, kindly see, that is annexure 13. 13 and page 19/6, Lordship, the operative.
In fact, I have seen, this is the experience which I have gained.
Lordship.
Here.
Lordship.
That in most of the cases.
Lordship.
They fell.
They are suffering, man. Within 7 days, they are suffering.
No, don't make that statement. Lordship, what I'm, in fact, Lordship, it is, if Lordship kindly see the very language of that clause, it is, Lordship, in fact, arbitrary. Lordship, kindly see.
All right, let us see. We will decide it on merits.
Lordship, 96.
Dengue is what sort of?
Lordship, kindly see page 7.
Sort of fever.
Please let him.
Viral fever, my lord. Viral fever.
Please allow him.
Lordship, page 96, Lordship, kindly come to page 96.
Yes.
Lordship, on examination with your reply dated 25/7/24, it is observed the condition laid down as per decision clause number 3, Roman 3, Lordship, that due to failure of depositing of required APS and IST by the selected bidder, his bid shall be cancelled. No alternative is permissible. So you have failed to comply with the provision of depositing of APS and IST within stipulated time. Your tender therefore cancelled forthwith. So, Lordship, my humble submission, Your Lordship, kindly see, Lordship, because the tender condition itself, Lordship, gives Lordship their authority to confirm, to make sufficient of the notice by registered post with a Lordship, not only by email, because there is a terms of contract, and they have admittedly they have not sent it through the AD. And in fact, Lordship, I was not well, and I have not received that email on the relevant time. And Lordship can receive the arbitrary clause, Lordship, that speaks of letter of acceptance means, Lordship, I have to accept that letter of acceptance, Lordship. So unless, Lordship, I accepted the letter of acceptance, Lordship, they have.
You have made the offer, they have accepted.
They have accepted.
So you have to again accept that.
Yes, Lord. No, Lordship, the language they have using, Lordship,
Yes.
on the date of issuance, that is, Lordship, this is arbitrary sentence, Lordship. What I'm saying,
Sentence.
well, who knows, Lordship, when they are, Lordship, issuing that notice, Lordship. So that no, Lordship, because that is the reason the condition they have put in the 22.1 that it has to be confirmed by the rest of the letter. Lordship, kindly again I'm saying page, Lordship, that is their condition, Lordship, that is Lordship, page 54.
For your record, not that APS will come registered letter.
No, Lordship, registered letter, Lordship, because Lordship, kindly see there are 25 successful bidders. So, Lordship, by way of lottery, they selected me.
Okay.
They selected me as Lordship successful bidder. So, definitely, Lordship, after acceptance of the letter of LOI, Lordship, definitely within 7 days, I have to deposit the entire amount.
25 bidders, same rate.
Same rate, Lordship, because they have come up with that notification that they have fixed the opportunity limit. If somebody quotes more than 14.99, they will be disqualified. The bidder now is quoting less than 14.99. They have made this trend, Lordship. So 25 bidders have quoted with 14.99% less to the tender amount, Lordship. And by way of lottery, because Lordship, kindly see, Lordship, kindly want, Lordship, it will be clarified, Lordship, I can convince you, Lordship, in this way. Lordship, kindly come to Annexure 5. Page 65.
Blood testing was initiated or not?
No, Lordship, that is because Lordship, it's a bona fide mistake. It is not an intentional, Lordship. Because Lordship.
No, but this is the command of this provision, that not only it shall be cancelled, but proceedings shall be initiated.
Lordship, if Lordship, they will confirm, Lordship, they have intimated me by registering with AD, Lordship. If they have not done it, Lordship, it is lack of communication. I can't, Lordship, I can't submit anything, Lordship. Lordship, can you remember on the very relevant day, Lordship, I had, Lordship, that's why, Lordship, you should notice and direct them to take a decision. Because your tender condition speaks of, Lordship, it has to be confirmed with a registered letter. So, Lordship, they have not done it. If they will say, Lordship, they have sent it letter, then I don't have any case, Lordship.
Let us read that requirement again.
Lordship.
That registered.
That is page 32, Lordship. Page 32. The applicable additional.
First paragraph. Kindly read the first part.
Just. You are reading page 32.
Page 32.
32, well.
Page 2, Lordship. That is 19.3. They are relying this clause, Lordship, 19.3.
Yes.
From the top, my lord, Roman 3.
Yes.
Lordship. That is additional purpose in case of abnormality, low bids, Lordship, LB, Lordship. As per the Works Department Office Memorandum number 4559, WW Bhubaneswar dated.
Where is the requirement that it should be?
Requirement, Lordship, the tabular column just below, Lordship. The applicable additional preference security, Lordship. Just below the tabular column, Lordship. Lordship, got it?
Which part?
Page 32, Lordship. Page 32, Lordship.
Yes.
Same, that clause, same clause. I just. Page 32.
32, Lordship.
Yes. What is
I had
it?
pointed out, Lordship. Page 32. Lordship, just bottom.
Read it.
Lordship. The applicable additional performance security, that is APS, Lordship, in shape of term deposit receipt placed in favor of divisional officer, bank guarantee in favor of divisional officer from any nationalized scheduled bank in India counter guaranteed by its local branch at Bhubaneswar is to be submitted within 7 days of issue of letter of acceptance by the divisional officer by email to the successful bidder. Otherwise, the bid successful bidders further proceeding for blacklisting shall be initiated against bidder as per the Works Department Office Memorandum 1449 dated 2029-2018. This is the requirement, Lordship.
So where you pointed out somewhere registered letter?
Lordship, that is Lordship at page, Lordship, that is at page 54, Lordship. Page 54. Clause 22, page 54. Notification of award and signing of agreement, Lordship. Page 54. Lordship.
Page 54.
22, page 54, Lordship, clause 22, that is notification of, 21 speaks on negotiation of bids, then 22, Lordship, notification of award and signing of agreement. And 22.1, Lordship, the modality they have given. Well, Lordship, the employer oblique engineer in charge, Lordship, got it, Lordship. The employer oblique engineer in charge shall notify acceptance of the work prior to expire of the validity of the period of cable. Then through the cable or email confirmed by registered letter. So, Lordship, due to avoid this inconvenience, Lordship.
Inconvenience.
Lordship, because I was not at the relevant time.
Because that clause, I think that is very specific. By email, it says only email.
That is the email.
Yes.
Subsequently, they, in the same time notification, they have clarified this, Lordship. They have entered modality they laid down as page 54. This speaks of the entire modality of the how to execute agreement, Lordship. That is the terms of contract. In this contract, they are saying, Lordship, it has to be confirmed with the registration of the letter. So if they have said, then I don't have any case, Lordship. Lordship, kindly see, pursuant to Lordship's direction, gone through, Lordship, they have communicated twice to me, Lordship, by email and letter. The subsequent letters, they have followed this principle. Lordship, kindly see, I have annexed all those documents. Your Lordship, kindly see, come to.
What is the expiry or validity period?
In fact, 90 days, Lordship. This is every contract that is 90 days. For period conditions, the period court speaks of, it is 90 days. But it's subject to, Lordship, if the successful bidder can extend his validity, Lordship. It is up to the successful bidder, he can extend his validity. So it is, Lordship.
Eligible bidders.
Eligible bidders, Lordship. That is up to them, they can extend their bid validity, Lordship. So, Lordship, if they are not cancelling, Lordship, I am ready with, I have already submitted all by APS, Lordship, immediately after, Lordship. And now, Lordship, the officers are ready. Because of this clause, they are unable to, Lordship, proceed. Otherwise, they will come with the pre-tender and it will be another burden to the state, Lordship, and they will come up with another process. And they have accepted my recommendation, my entire APS. But due to this clause, Lordship, because admittedly they have not followed this, they have not sent it.
Yes.
Lordship, kindly see 9 for the letter of acceptance, my lord. That was issued on 27/6/2024.
No, but whether there was any compliance of this 22.1 or not.
That I have to do, that I have to take instruction.
You'll have to take instruction because it is very clear.
My lord.
It says employer engineer in charge shall notify extension of acceptance of work prior to expiry of the validity period by cable, telex, or facsimile, or email.
My lord.
Confirmed by registered letter.
My lord.
So you may say that email was sent, but you will have also to prove that only email, a registered letter was also sent.
Well, that part I will take instruction. But Lordship, kindly
you have to take instruction, otherwise.
My lord, Lordship, kindly see page 72 for a moment, my lord. Page 72, my lord.
Any idea about that rate?
My lordship.
Because we remember the previous you had filed,
That is second communication, lordship.
you had taken a specific stand that we have not received the email. So we wrote down your contention and asked you to file an affidavit whether you have received or not.
Lordship.
You withdrew that writ application.
That is regarding the communication of the Annexure 13, lordship.
No, anything. See, according to you, the in terms of the this 22.1,
Lordship.
the email was to be followed by a registered letter also.
Lordship.
What is the purpose of issuance of the registered letter?
Only to confirm, lordship.
Only to confirm that it was communicated.
Communicate.
Now, is it your case that you had not seen the email?
Lord, I am not. I was in medical, lordship.
All right. Where have you said?
Lordship, that is in my entire case, lordship. I give the medical certificate and
give
medical
certificate.
Lordship, kindly see page 72.
No, medical certificate is there.
I have
You have
given,
given.
lordship.
Very difficult. Show us the medical.
No, my lordship, Honorable Justice Ross
72
pointing out.
miles.
So far, the communication of disqualification, lordship, they have rejected letter. They have.
No, I remember because you
That
had
is the
said I
second
have not received the email.
That is second communication.
Okay.
Forget that case. Forget that case. Let us come to this case.
Lordship.
According to you, there was an email sent.
Same.
The email you did not receive because you were suffering from some ailment.
Lordship.
You have given particular ailment which you were suffering from.
Lordship.
And then you were hospitalized.
Lordship.
This is the plea which you are taking.
Lordship.
All right. Had you received the email, had you been well and received the email, you would not have taken this plea that this is bad because it is not supported by any registered letter.
No.
All right. The whole purpose is of communication that was communicated.
Immediately.
Now, stand which you have taken as regards to
Immediately, I have page annex
Page 72, ma'am.
Let him finish.
Lordship, 71, lordship, kindly. Immediately on 6th, I released lordship. Immediately.
No. When were you admitted?
Admitted lordship on lordship that admitted lordship since lordship that is an
Certificate is there somewhere.
lordship that is from lordship.
When was the email issued?
Email issued lordship on as per them 27/6 lordship.
27/6/2024.
2024 lordship. 24.
And when were you admitted?
Lordship, I have admitted lordship since first July.
1st July.
1st July
2024.
24 lordship.
So in the meanwhile, you did not check your email.
No lordship, because I was suffering from fever lordship. Because I was suffering from fever, I hospitalized on 1st January lordship, 1st July. So that is the reason inconvenience I could not check up lordship.
So everyone has to take care of one aspect.
Lordship.
That one can take, one can converse a legal issue.
Lordship.
But if someone relies on factual aspect, that is found to be incorrect, then even if you have a right to get,
Lordship.
even if you have a legal right to get, you will not get in a proceeding under Article 226. So let us see your certificate.
Lordship, kindly come to lordship, page 72 lordship.
Page
72.
Yeah. Is he a doctor?
Lordship.
I have my doubts.
Lordship, doctor.
Okay, letter number, nothing.
Lordship, everything is there, lordship.
Letter number is there.
No, letter number, no, but it is a certificate issued by doctor, lordship.
I wish him all success.
In the tender or what?
See, the doctor in the medical certificate records, I wish him all success.
That is easy understanding, Lordship.
The
because
understanding.
I can say.
Therefore, you were suffering from such a disease that you had to go to a doctor who is given this certificate.
Wish him all success. You told him I need it for a tender, he has wished you all
And
success.
suffering from viral fever.
Dengue is
Not
a-
like that.
dengue is a viral fever.
All
that is
right,
also-
Physically, I usually come. No, but taking pleasure.
What happened, sir?
Well, Lordship, they're laughing or taking pleasure by getting a dismissal order. If we failed in case, they're taking pleasure. Lordship, what is this? We're coming with litigation to get relief, but are they enjoying? Lordship, this is unfortunate. Lordship.
This is not the way.
This is unfortunate, Lordship.
Mr. Dalai, this is not the
Lordship,
way.
when we are losing a case, Lord, they're taking pleasure. Lordship,
How are you sure that you're losing the case?
Lordship. But we have some, Lordship.
Yeah, this letter is causing the laughter, nothing else.
Lordship, maybe, Lordship, but that is my document.
Yeah.
God bless.
Item number 10.
Your Lordships, this is a matter where we were protected by an interim order and that our shops shall not be demolished. And Your Lordships, just even though the interim order is operating, they have demolished the shops. That's why the contempt today. The main matter, of course, is pending also before this bench itself.
Where is the interim order?
Your Lordships may just look at page 15. Just the main auditor card there. Restart. Page 15, Your Lordships, considering.
So this order was passed in 2016.
Yes, Your Lordships, that has also been extended, allowed to continue, and the matter has not been listed thereafter. Your Lordships, the continuation order is at page 20. And we did show them that order. The thing is, first they did come and say that we are going to demolish. We did show them that order also, that this is still in operation. Please take instructions from one side.
So what is
Page 20.
this order? 6/12/2016?
Your Lordship, that was an order for demolition.
No, where is that?
Your Lordship, the main writ hasn't come. That's why if Your Lordship's permit, I shall show from my brief. Next one.
And what happened to this? The order of this court dated 22/8/2016. There is reference, just see, progress is case on 1 week, along with the reports of WPC number 22236 of 2016. Yes.
Item 11.
By order dated 12/1/24, Your Worship. The order is at page 9 and 10 of the contempt application.
Page 9.
Page 9 and 10 of the contempt application, I have enclosed the order, Your Worship. A relevant para would be at page 10, paragraph number 4, Your Worship. May I read? Directed the state opposite parties to comply with the order and to remove the enforcement within a period of 3 months, Your Worship. Until that order has been complied with. Tahsildar admitted to have initiated the enforcement proceeding though. Has been complied with.
Whether the private party was issued notice
No, Your Worship.
without noticing.
Your Worship, private party was, have to verify, Your Worship. I'm not
No,
sure.
no, it's clear from the order.
In the order, there is no representation from the private party, Your Worship.
And
But the counter affidavit was filed by the Tahsildar, in which they have intimated the honorable court that has been drawn up against the private encroacher, Your Worship.
yes,
But in the meantime, I have obtained instruction from the Tahsildar that on 23rd September 2024, they've been evicted, my lords. And photographs have also been given by the Tahsildar. This is the
you
instruction.
filed affidavit.
No, affidavit has not
Filed.
been done. Yes, yes, ma'am.
1 week.
Yes, ma'am. All right.
Much
GA appearing on behalf of the contenders who has submitted that this court's order dated 12/1/2024 has been carried out and the unauthorized has been removed.
Yes.
So far, as requested, list this matter on and for 1 week, so as to enable him to file a compliance.
Much appreciated.
So already.
I have filed counter.
Copy of the counter. Can it come day after tomorrow?
It will come. Yes.
Well,
So what is the position?
There is nothing, I was just glancing through it before your lordship entered into it. I think they have only compiled and chief secretary has done nothing.
They want us to do something.
Your lordship directed that in the meantime, chief secretary may look into the matter. Chief secretary didn't look into the matter, compiled the counter, both the counters of the forest. That is proven that I exactly
All right.
don't know.
Item 32.
My lord, the item number 32, the second item, my lords. WPS number 36871 of 2020, your lordships. I pray for an adjournment, my lords. Why? Engaged for the matter, your lordships. He is not available today physically, my lords. The difficulty, Mr. Counsel, is that this case has been specially fixed to be taken up at 2. Yes, my lord, I acknowledge, my lord. If the matter is not that urgent.
So 32, so first item I'm appearing with. Second item my friend mentioned. First item should be taken up separately. It doesn't have any, though the legal part may be same, but factually it is different. It has been mentioned with this item. So both can be independently heard.
So why were they asked to be taken up together?
Together actually is not required. Actually, as far as the facts are concerned.
So is there any order?
Yes, madam, there is a direction to tag it.
Then how can?
We can do that.
There is independently here. Factually, both are a little bit different. These are regarding the IPR benefit, where in our the first case, there has been a recommendation.
No, where is the order?
The lordship looks at order.
29/11.
29/11, 2021. Is it not tagging list is along with writ petitions also?
So is there any interim order in your case? No, madam, no interim.
There is no interim order.
No,
There is no interim order.
And we the at 2 p.m. No, not this one. Why have you gone?
Why has it been serially listed?
Serial.
If there was a memo, why has it been listed? Last listed long.
There is a petition. Actually, I filed a petition to separate it. Maybe that's the reason it has been listed.
Oh, you have filed a petition?
Yes, yes, I have filed a petition. It is IA 9957 of 2024.
Order. This matter later, Mr. Mishra.
Yes.
When do you want? My lord, as per convenience, my lord, somewhere in December, my lord. Oh, easy practicing here. Learn senior counsel practices here, my lord. Oh, no, he's not. He's outside. Mr. Chidambaram is
Chidambaram, he says Mr.
Chidambaram, my lord. Number is too far. Week commencing 18th.
That is 1 month only. 11th week, reproduction or third week? Recommencing 11 on 11. Link to what?
What is common in both the cases?
Common is this, they are challenging the amendment of the IPR. In both cases, amendment is challenged. But in our case, the factually, my case has been recommended. Their case has not been recommended. So essentially, they may not get the benefit, but I'll get the benefit. The promissory estoppel and the legitimate expectation, such matters have already been adjudicated by the Honorable Court in a different context, and that is also covered practically.
You go in WPC number 4, second item. The counsel appearing on behalf of the petitioner seeks adjournment. Top. List. Let the matter be dealing on the main matter, that is WPC number so and so, and be listed on for 6 weeks.
But, sorry.
WPC number so and so, that this case will be listed on 1 week next week. Who is for the other side? You are preparing.
But I am for the statement.
But amendment to the IPR 2015, both have been challenged in the, I mean,
Yes,
both
yes.
writ applications same.
Factually, their case
No,
has not
factually is different,
recommended.
but we are challenging
Therefore,
that
independence should
amendment.
be hard. I said it should be separated and independent.
We will hear you.
Yes, yes.
The other case will depend on the decision.
Yes.
Item number 33.
In item 33, I have received instruction from the government, the legal heirs. I will file a substitution petition. In the meantime, the respondent has expired. May I pray for 1 week, my lord?
1 week.
1 week.
Yes. And requested on behalf of the appellant, just this matter on 1 week, so as to enable him to take steps for consequent upon the death of opposite party member, respond number 1.
Yes, ma'am.
Yes.
Item 34.
Yes.
Sorry, madam.
Case number.
What happened? File is missing, allotted.
Yes.
Lookout notice.
Where is the opposite respondent?
Wait up, my lord. I have got the file. This is entrusted to Sashwat Das.
Two sets of counsel appearing from the respondent, but nobody is there.
Yes, Mr.
Miller, I am appearing for opposite, but not 3.
Yes. Tomorrow? Well. Listed on behalf of the Tomorrow.
35.
35, I have taken consent from my friend, my lord, day after tomorrow. That file is, I have taken consent from my senior.
Day after tomorrow.
Mr. Dhruv Mehta, Senior Counsel, is appearing through this.
My lord, I beg to appear, my lord, on behalf of the petitioner, my lord, in item 36, my lord. My lord, this concerns the applicability.
Just a minute, Mr. Mehta. Just please wait. Wait for a minute.
Yes, my lord.
You are for whom?
I appear for the writ petitioner, my lord.
Which item?
Item 36.
Item 36.
May I address your lordships, my lord?
Yes, yes, Mr.
Yes, my lord. My lord, in this case, my lord, the legal question I'll just indicate. The only thing is, my lord, the pleadings are not yet complete because state of Orissa and, my lord, the central government, they have, my lord, not filed their replies yet. So I just indicate what the matter is about, my lord. And then, my lord, perhaps they may be seeking time. My lord, this concerns the applicability of Rule 45 of the Mineral Concession Rules of 2016, my lord. Whether it would be applicable for determining, my lord, the price at which, my lord, the metallurgical grade bauxite is to be sold to end users in the state under the linkage policy of the state, my lord. That's the question, my lord. Alternatively, we have said, my lord, first we have said that it's not retracted, and I will indicate that, my lord. Alternatively, we've also challenged the vires of Rule 45 as being ultra vires, my lord, Section 13 of the MMDR Act, and on several other grounds, my lord. Therefore, my lord, the Ministry of Mines, my lord, central government, I respectfully submit, is a party who must file their reply affidavit to this petition. In fact, my lord, on the last occasion, my lord, a direction was issued while granting us the interim order for the respondents to complete their pleadings. OMC has filed its reply, my lord, and the state of Orissa and the central government, my lord, have not yet filed their replies, my lord. So as soon as pleadings are complete, my lord, whenever your lordship wishes, my lord, I will come down and we can, my lord, argue the main matter, my lord. And my lord, interim order.
In this case, my lord.
Yes.
In this
Interim
case,
order.
I have already received. So kindly grant some time. We will file a counter affidavit for the state, my lord. In fact, the
Counter affidavit for the state, but this order was passed in May 2023. We are in October 2000.
My lord, in fact, my lord, the virus of the Rule 45 is challenged.
Yes.
Because state government has directed to implement the sale price pursuant to the Rule 45, my lord. So Rule 45 is under challenge, my lord. So
That is an alternative argument.
My
That is an alternative stand which the petitioners have taken.
my lord, within a week, my lord, I have already finalized, my lord. Within a week, we will file counter.
I am appearing.
I have already informed my
number
senior.
one. I have filed my counter since long, but no rejoinder has been filed till date.
All right, they will not file any rejoinder.
My
Ministry.
Within a
So
week.
can we post this after 2 weeks?
My lord.
So that in the meanwhile you may file rejoinder if required.
Yes, my lord. Your lordship can do that, but I wondering whether anybody is appearing for central government because their stand is necessary in the matter because there's a challenge to the wiries, my lord.
Central government? Who is for the
Yes,
central
my
government?
lord. Yes, Mr. Kashyap and Mr. Padi.
Yes, I'm in virtual mode, my lord.
Yes, he is appearing.
My lord,
No, since you are challenging the virus, counter affidavit may not be required. So based on, do you intend to file a counter affidavit, Mr. Padi?
my lord, if they have challenged the virus, first may hear it without the counter. I will try my best to fight, but it is not because challenge virus is.
Your call, you decide.
I will
If you
try my
want-
best to file, otherwise, Lord, may proceed according to law.
Despite the court's order dated 15/5/2020 in matter, the opposite parties, except opposite party number 1, have not filed their counter affidavits by way of indulgence. 1 week further time is allowed for filing of the counter affidavits after serving copies thereof on learned counsel representing the petitioner. List this matter on 2 weeks. Time in the meanwhile may be utilized for filing rejoinder if so required.
Lordship, please. My lord, interim order to be extended because it was only till the next date, my lord. If your lordship sees para 5 of the order dated 19th May. Para 5 of the order dated 19th May, my lord.
No, what is the order?
My lord, the interim order is, my lord, that I will continue to purchase, my lord, bauxite at 1,000 rupees per metric ton, my lord. And I have given an undertaking that in case I lose, I undertake to pay the differential. That interim order is being continued. I'm sorry?
You are reading which order?
My lord, the last order is 19th May. And if your lordship sees para 5 for a minute, my lord. May I read that? After hearing learned counsel for the respective parties and considering the urgency involved in keeping in view the fact that the agreement has already been executed between the parties on 16th May, and also petitioners suffering because of non-supply of bauxite to its industry, this court, in modification of the order dated 15th May, direct that the interim arrangement as has been made by this court-wide order dated 29th March.
That will continue, Mr. The interim order with the observations as made in paragraph 5 of the order dated 19/5/2023 shall continue in the meanwhile.
Item 37.
Lord, your lordships have indicated any date, my lord?
Date 2 weeks.
All right.
You will get the date.
Very well. Very well.
37.
Please, Lordship. On the last occasion, Lordship issued notice to private to opposite parties. The writ appeal, my lord, challenges the order of the Honorable Single Judge, where by which, my lord, the certificate issued to this petitioners is turned down despite the concurrent finding of all 3 forums below, my lords.
All 3 forums
below. First, the first round of litigation started challenging my appointment, my lords, being an Anganwadi worker, in which I have produced the resident certificate issued by the competent authority on basis of the documents available on record, my lords. In that petition, lordship directed to the collector, my lord, the opposite party number 3, to dispose of the representations, my lords. The opinion number 3, my lords, the collector
challenging this order of review.
This review also, which I filed a review, the lordship, the Honorable Single Judge, in the review order, said that I can go in appeal, my lords. That's my kindly see page.
So did you prefer appeal?
Yes, yeah. Yeah. This can be corrected in appeal. That was that observed in the.
So you are challenging
the
which
review.
order?
I'm challenging the review order as well as the order of main order. Judgment dated 24/4/23, my lords. Both.
How can you do both? By filing appeal against the first order, you accepted.
My lord.
How can you assail that?
There was an error, my lords, in the main judgments. I filed a review. Lordship said that this can be corrected in appeal.
So therefore you file appeal.
I filed here appeal, man.
But why should you challenge this order? 21/12, you accepted this order.
Yes.
So you cannot challenge this.
It's a main order. I can skip that challenge, my lords. May
so where is
stick to the main order judgment, page 32. Page 32.
Annexure?
Annexure 2, my lords. What has happened here in this case, my lords? Honorable single judge led fresh evidence, my lords. Additional evidence was taken, so moto, adding a fresh party in this writ petitions. And on the basis of the fresh evidence, this writ petition was disposed of, saying, allowing and directing for cancellations of the certificate of residence, my lords. Let's me kindly please come to page 32 and the relevant portion is page, my lords, 45. Page 45 and middle, my lords, lordship say, in not ascertaining the point of supply, so electricity bill, my lords, in the questions, there is omissions and error apparent in two impugned orders. They were made based on irrelevant evidence. Upon earlier directions herein as aforesaid, the supply company has positively stated that the supply was made under the bill and the consumer number to a location in village Nilakantapur. This assertion of fact has not been denied by opposite party in the objection filed with the affidavit. The point of supply electricity under the bill relied upon by opposite party number 5 was a relevant evidence. This evidence was not called for by the authorities, neither nor considerations directed on remand. The same situations had been dealt with by them earlier on the orders set aside by the division bench. It appears the two authorities in tandem acted mechanically in returning the same findings on the same documents, where there was no local inquiry ever and the inquiry report had been said to have...
What was this dispute about?
My lord?
You are representing whom?
I'm representing the petitioners, my lord.
Petitioner, appellate.
No, not consumer. I have been selected as Anganwadi worker, my lords. My certificate of residence was under challenge, my lords.
Yes.
Lords, may kindly come to page 48, the order of the collectors, my lords. First, my lords. Annexure 4, my lords.
You were the petitioner.
You were
the respondent.
Respondent.
Your
they are in the
certificate was under challenge.
Petitioner challenge the order of the sub-collector as well as the tahsil in the writ petitions.
On what ground?
On the ground that certificate was not issued basing upon the correct documents, my lords. All the three forums, my lords, including the collector said.
Forum is not important.
Yes, nine documents was referred as per the rule 48, my lords. 1948 rules. Request 3 documents, voter list for residential purposes that was in produced, my lords. The collector says, my lords, 9 documents in favor of this petitioners, my lords. Let me kindly look to page.
All right. So thereafter, what are those documents?
Those documents are, my lords.
Voter ID card.
Voter ID card, school, college, school living certificate, college living certificate, birth certificate of my daughter. Then, my lords, the Sarpanch has given a certificate of residence, my lords. On local inquiry, RI has given certificate, my lords. All those 9 documents, 9 evidence has been led before the Tahsildar. Certificate was granted, and thereafter the appeal is also confirmed by the sub-collectors. On a writ file, when it was directed to the collector, once the collector while upheld my appointment, also spoken on the certificate that it is correctly issued by virtue of this document. Thereafter, the writ petitioners, the respondents, no one here in minor challenge in a writ, appeal in a before the sub-collector matters, challenging my original certificate issued in the 2006 matter. The sub-collector's mailers remanded the matter to the Tahsildar. Thereafter, I approached this Honorable High Court. Honorable High Court set aside the sub-collector's orders, directed to the Tahsildar to give a fresh findings. Fresh finding is in my favor, my lords, considering all these 9 documents, and the certificate was confirmed. Thereafter, again, he appealed in sub-collector, that is confirmed. Then approached to High Court, my lords. Honorable High Court in single bench, my lords, so what took a fresh evidence, reappreciated the fresh evidence also, took a fresh evidence by the electric department, my lords. Because electricity bill is also one of the document produced before granting the certificate, my lords. So, though the electricity bill is in my favor, my lords, so speaks of the same village I reside, the GPS measurement given by this newly added party, the electricity department says that no, this is some other village. That was the evidence taken, and my certificate has been cancelled. So under 226, this substantial question of law is involved. In the society proceedings, how new evidence can be taken under 226 or 227? I have cited 2-3 judgments of Honorable Supreme Court. That is the question in this case, my lords. 3 forums below has given in my favor. And in 2005 appointment, I have been serving still now, my lords, working till as Anganwadi worker. May bring your lordship's notice to first collector's finding, my lords. How 3 forums have been found that certificate has been issued as per the rules, ma'am. May I read page 53, my lords?
Yes.
Private opposite party, lordship.
I am for private opposite by law.
Yes.
What happens in this case, the petitioner is a resident of Dinyari.
Petitioner is a resident of village A or not is a question of fact.
Yes. See, yes,
just a minute.
Yes.
Is a question of fact.
Yes.
The authorities fair of the opinion that he or she is a resident of village A. This is their finding. That finding has been caused by the learned singular. All right.
Yes.
What is the meaning of that? That she is not a resident. Whether she is a resident of that village, depending upon some it cannot be held that she was not a resident of that village.
And she has produced the ROR in respect of village Nilakondamurpunal. She has produced to obtain the residence certificate. He has filed the
What is resident certificate?
Residence to obtain residence. He has filed the ROR in the 1984 rule. only to produce the ROR. There is no provision to produce other CLC there, RLC in
So
2007.
what is required?
Recall the ROR, my lord. The ROR in respect to ROR, it was in Nilakantapur.
ROI is required for.
Yes, my lord.
Do you mean to say if somebody is staying on rent, you can't get a resident certificate?
In 1984, there is no provision. In
Yes, Lordship,
2008
you
came.
can, provided you are in the same place for continuously for a period of 1 year.
Yes, that is the rule.
In 2017 it came, my lord. In 2017 it came, but prior to that, the 1984 rule was there. In 1984, there is
This
ROR
relates to what? Which period?
in 2005.
2005, what was the position?
Position is that he has produced the ROR of Nilakantapur. RI has submitted both RI Nilakantapur Dineri.
So there is difference between ROR. I can have ROR for.
When he has
in
more.
Karnataka.
May not be residing there even if you have land there.
Yes, it is now we are obtaining.
So certificate has been granted in the year 2005.
2005. 2006, my lord, or 2005.
See, cancellation of certificate, will it mean that she was not resident of that village?
Yes, ma'am.
How can that finding be reported?
But he has applied for, he also applied for, he has in Nilakantapur. He is a resident of Nilakantapur. Your lordship may come to answer.
Past certificate of birth. And when was the bill, this electricity bill issued?
It was 2003. She was relying the electricity bill of 2003. ROR of 2005. He purchased land in 2011 as a from
Difficult, Mr. Counsel.
Your lordship come to answer 3 of the review petition. Well. Answer 3. He has filed also. That he is a resident of Nilakantapur. He was selected as a resident of Nilakantapur. Your lordship come to page 47. Answer 3.
This selection was for which village?
2005.
Which village?
For Dineri.
Dineri. According to you, she is
from Nilakantapur.
Huh?
She Nilakantapur, she has applied as a Nilakantapur, resident of Nilakantapur. Your lordship come to answer 3 in the review petition, page 47. The select list.
Annexure 3.
Annexure 3, page 47 of the review petition.
No. Page 47 in the application.
Yes, madam.
Page 47, there is no page 47.
But they have supplied the copy as 47, madam.
Must be of
the all right. Which page of the review application? Internal page.
Madam.
What do you want us to see?
That he has applied as a resident.
No, what document to see?
Annexure the select. Annexure 3.
Step 3 of the writ appeal.
Writ appeal.
Yes. Copy of the result sheet.
Result sheet.
Yes.
Where Vanalata Sav, wife of Ghanashyam Sav, art in Nilakantapur. She has applied as a Nilakantapur.
Page 47.
Yes, ma'am. Annexure 3.
Not applied there, but she has given her address as that.
Address is because he is resident. But the advertisement is issued in favor in respect of like linear.
Page 61. Is that result sheet, page 47. Running page 47.
Stop page. Digital page.
Page 71. Model format of result sheet.
Yes, ma'am.
How's that? Page number, yeah, page number.
These are the annexure
Digital
three.
page, digital page.
71.
There, yes.
The petitioner name has mentioned as Bonolata Sau, wife of Ghanasam Sau, at Nilakontapuru, post Bhogoda, East Khorda. He has applied also residency for Nilakontapuru Mela. He has produced the ROR of Nilakontapuru. Everything will be clear if you will read petition Mela. I have annexed our application for inquiry report, everything is there, Mela. Annexed one series in the read application.
Where is the
Read petition,
advertisement?
Mela.
Where is the advertisement?
Advertisement. So advertisement in the earlier writ petition, there this is fifth writ petition, my lord. This is fifth writ petition. 3 by the this is OP5, and by the petition. So let's come to the answer one series of the writ petition, everything will be clear, my lord.
Odisha local laws, Odisha miscellaneous certificate rules 1984.
Nine.
84 rule.
All right, we will see. We'll pass orders. 3 weeks.
Item 38.
But I'm
Please.
there. I'm at 37. I'm there for the opposite part. 37.
37 you are for?
Opposite part number 6. The electricity discount.
All right.
No bless.
Yes.
Item 38.
Please, my kind attention of my lords.
Yes.
I am for the appellant, my lords, in this case.
Yes.
And my lords, we have challenged the judgment of the learned single judge on the ground that the learned single judge has not taken into consideration the effect of the amended section 39 of the Insurance Act. My lord, the issue before the learned single judge was as to who is entitled to the benefit of the policy after the death of the policy holder, whether LRs as per succession law or the nominee mentioned, specifically mentioned in the policy.
Yes.
So, my lords, may kindly have for a minute the impugned order. When a single judge has not, has taken note of, but not given any, finding on the effect of section 39 amended section. We kindly have page.
In this case, your
19.
lordship had entertained the appeal and had issued notice. So I'm not sure whether the insurance company has appeared. There was specific direction on the last occasion.
Who is appearing?
Yes, we have filed the requisites, we have served them. And
Who is appearing for the insurance company?
Mr. Nirmal Mohanty has been served with the and he has been appearing in the last date of hearings. This matter has actually been listed for the last 3 dates, but not reached for hearing. And his presence is there.
ICICI Prudential. Who appears?
Well, Mr. Nirmal Mohanty is the counsel for ICICI Prudential for our respondents 3 and 4.
Whether his name is reflected?
Yes, yes.
Not up to date. Keep surveying. Office note. Notice issued 3 and R4, fixing 3/9/2024, appearance and chauffeurs.
For 3, I have appeared. I have appeared for 3. Respondent number 3.
Yes.
3 is IRDA, Insurance Regulatory Development Authority.
And 4 notice was issued to 4 also.
4 is supposed to come.
Because there was no representation. What is the service report? 4?
Yes. We have filed the requisites.
One moment. We're just checking the office note regarding
Please,
source of notice. The last note says admission, notice of admission issued. Thereafter, they have to say somebody has appeared. Where is the
6/8/2024.
where is that office note? We don't have.
6/8.
Into the 9/8, there's a note on 6/8 that it has been delivered. Then
Actually, it tells you instant like 21.
Well, it's the main. May I submit, my lords? May I speak?
Cannot speak unless we are sure that
Please. Sorry.
respondent number 5 has entered appearance.
Yes.
Served notice. Served.
packing report shows that item delivered to addresses. X and Y shows already.
from the. Is there any office? From the compare that notice upon respond number 5.
Four.
Respond number 4 has been validly served.
This note shows that, the evidence is present when Nirmalia Mahanti associates have appeared for R4.
Learned Mr. Nirmala Mahanti, learned counsel has entered appearance on behalf of respond number 4. So, however, there is no representation on behalf of respond number 4. List this matter tomorrow. Please inform.
Please, Madam, I'll do that. But can it be listed in the first, say, 20 matters, because after much wait it has reached and there is no stay. There is no stay in my favor.
Come tomorrow.
Please.
Next.
Item 39.
Please, Madam.
May I please, your lordship. Commander, is the present petitioner appellant has filed this intra-court appeal and have a glance to page 115, madam. This is the impugned
Let
order.
us see the order first.
Yes, madam. That is 115, madam.
Yes, sure.
This is, madam, annexure 10. Dated 26/7/2020.
Yeah.
Under that writ appeal which has been disposed of by virtue of the order of this honorable court on 18/6/2024. In this order, it has been directed to appear in that writ appeal by filing the appropriate application. My lord, kindly recapture your memory that appointment of that 20,000 post for the trained graduate teachers, which was this
Yes,
single judge has passed the order, merit, preference come merit as per the advertisement. Subsequently, state came up in appeal. This honorable court has been directed, no, it should be merit come preference. So on that score, after the judgment of my lords, so annexure 2 has been issued. For a moment, annexure 2. It is the relevant page is page. Page 45. It is dated 10/7/2024. The draft result sheet in respect of the
yes, who is for the estate? Yes. How can we sustain this order?
Actually, your lordship may say, this is a writ appeal, my lord. This has challenge the selection process.
No, come to
110. Yes, ma'am, I have that in
paragraph 5.
Yes, it can be decided for the honorable single judge. But those who are to be affected, they are not made parties.
Not required. That will be decided in single judge.
Yes, yes, ma'am.
In fact, we all are appearing for the selected candidate, we got the appointment, but that has to go back to the single judge, because single judge has to decide.
Yes,
we can't.
When there is no matter
that is correct, absolutely correct.
Yes, yes.
That is correct. And some matters are also pending for the single judge.
The present writ appeal has been preferred against an order passed by a learned single judge of this court dated 26/7/2024 in WPC number 1 of 2024. Paragraphs 3 and 4, paragraphs 3, 4, and 5. Which reads as under. What is it? So, assailing the impugned order, and counsel appearing on behalf of the petitioner has submitted that since the writ appeals have been decided petitioner cannot approach the writ appellate court by filing appropriate application. So stop. Next, learned counsel appearing on behalf of the petitioner appears to be correct. Stop. The grievance raised by the appellant in the writ petition could have been addressed by the learned single judge, taking into account the decision of this court, or the division bench of this court in WA number 580 of 2024. Stop. The impugned order accordingly deserves interference and is set aside. The matter is remitted back. WPC number so and so stands restored to its original file. So stop. Let WPC number so and so be listed before appropriate bench according to the assignment.
Obligation.
Submission.
Okay.
Item 40.
Please, madam. But in this matter, I'm seeking my lord's permission to withdraw this appeal, my lord. The issue in this matter has been settled, my lord. On the instruction of my client, my lord, I'm seeking my lord's permission.
Front counsel for the appellant. So have you, are you operating systems? Mr. Satyam, Sanjeev Joshi seeks withdrawal of the present writ appeal on the ground. The writ appeal, since according to him, the dispute has been resolved. So, application, the appeal stands disposed of accordingly.
In this case, I'm appealing for the respondent, madam.
Yes. And counsel for the respondent does not have any objection to such withdrawal.
Item 41.
Please, your lordship. Item 41, we have received the counter. In 2 weeks' time to file rejoinder, your lordship.
My lord, I'm appearing for the respondent number 4. And your lordships have already issued notice to me, and if I may permit, my lord, your lordship may kindly permit me to at least show the one section, my lord, one rule provision, where this particular application is not even maintainable. Simply because the rule number, because there has been a change of law.
The counter.
So
there has been a change of law.
He wants to file a reply to your counter affidavit.
I'll file that. I just wanted to show to your lordships actually the relevant, the submission is at page number 4, where they refer rule number 58. That has been already done away with the 2016 amendment. The old law is no more there. And in virtue of this section, rule 4, sub rule 12, this application of 2000 is no more valid pursuant to 2016. That's the limited provision I wanted to. And in form of filing a reply, we are already operating since 2016. That area is no more available at all.
You are referring to which page?
The page number 4, my lords.
Page number 4 of your counter affidavit.
No, the page number of the petition, the review petition, where my learned friend has quoted the relevant provision of Rule 58, saying that it has escaped your lordship's attention for the purpose of this petition. So Rule 58, which is quoted under the Rule 2004, is no more available pursuant to 2016 rule. And that's
Just a minute.
page 4, paragraph 5.
Page 4, para 5.
Yes, my lords. Your lordship will see the quote relevant provision is 58, that that as per the provision of Rule 58 of OMMC Rules 2004, where an application for grant of renewal of the prospectus so dies before the order granting him a license or lease, or its renewal is passed, the application for grant of renewal of the lease shall be deemed to have been made by his legal.
What is your submission? What is your submission?
My submission is that since in the review petition, my learned friend quoting the Rule 58 saying that this has escaped your lordship's attention, my submission to that effect was that Rule 58, which my learned friend is trying to justify his right for which the writ petition was filed, that Rule 58 pursuant to December 2016 is no more available. And that is the rule number, Rule 4 of the Rule 2016, which says all application made as on the date of December 2016 is ineligible from the enforcement of the new rule of 2016. Therefore, the Rule 58 no more there at all when we will speak about this today, pursuant to 31st December.
1 week. And is allowed, as requested on behalf of the petitioner, to consider the counter affidavit which has been filed on behalf of opposite party number
1, 2, 3.
1, 2, and 3. All right. 1 week, Mr. Das.
Sure. I'll do that.
Item 42.
Last occasion when government council to take obtain instruction one time.
Yes.
In this regarding what another PL is pending, that is regarding that we have submitted detailed counter in that 15395 of 2015. Your lordship is hearing this matter. That is regarding that false certificate by the employees of some teachers, and we have taken action against them. If this matter can be tagged with that
List this as
18752 of 2018.
as jointly requested on behalf of the parties. List this matter with
18752 of 2018.
WPC.
15395 of 2015. Both the matters relative.
We have the dates.
Dates
Dates are not there. All. Next.
Lords, in item 43, my lords, we have received the counter filed by OP number 1 and 2, my lords. We have received the paravise commentary from the petitioner. We may be given a week's time to file rejoinder to the same, my lords.
Well, 1 week time is allowed to learn counsel for the petitioner to file rejoinder to the counter affidavit which has been filed on behalf of the opposite parties. Yes.
Item 44.
Matter on 1 week. Yes.
44.
May I please your lordship? My lord, I have received a counter in the last day of ensuing vacation. My lord, I am unable to file rejoinder. 2 weeks time may be allowed to.
2 weeks time is allowed for allowed so as to enable learned counsel for the petitioner to file a rejoinder to the counter affidavit.
Okay.
2 weeks. Yes.
Item 45.
45, my lord. This is a public interest. Last occasion, your lordship has issued notice. The matter relates to there are a number of road accident and death was caused. 60% died in 3 months, for which the present petition has prayed for implementation of Road Safety Council of 2015, for which your lordship has already issued notice, my lord. In the notice has sufficient, only opposite part number 8. He is not there. I may permitted to delete opposite part number 4. Now, my lord, the SP has filed a counter, my lord. There they have admitted already 37 persons, only 37 they have mentioned, already died in that period. But I have filed a rejoinder to show, my lord, there are persons who have been died in the accident, but it has not been reflected. I've got the paper from RTI. And another serious matter, my lord, when the matter is sub judice, I have filed an additional affidavit that two person from the Jharsuguda locality, they have come and threatened the present petitioner to withdraw the PIL, for which a FIR has been lodged. And FIR number Jharsuguda is case number 500 of 2024. Thereafter, matter.
So you are being pressurized to withdraw the writ petition.
Yes, my lord. And that when that matter, I have already, to apprise your lordship, I have filed additional affidavit. During pendency of this listing of this day, another two person with a police.
So the best course would be that you can leave this case.
Rasu, call for a status report from the IIC. Whether
we can continue. You leave it. Why should they come to you?
no, they have because that I don't know reason I have come to police for investigation.
Now, why should you inform the police? Let them deal with us.
Because he has his house twice they have attacked.
Therefore, ask your petitioner. The petitioner, we will delete the name of the petitioner. We will continue with the present litigation.
Oh, I am sorry, my lord. As your lordship pleases, so we'll continue, no problem.
We will continue with the litigation. The petitioner will not be there on.
So we'll assist my lord. Because we'll file a counter. Already admittedly, more person has been died, and that policy has to be implemented.
But why people are threatening you? What purpose?
I have mentioned in the FIR, lordship, that the withdraw this case. Withdraw this case.
How is that?
I don't know because
I can't understand.
So they want to kill people by.
it's not one incident. Twice they have attacked.
They want people to die in the accidents and get compensation. I don't understand. What is the practice?
Exactly. What is the modus operandi?
They want to say that I don't know. Mind strikes didn't serve it to that.
I said whatever.
Transportation of
because Jharsuguda
vehicles flying the Jharsuguda.
Yes.
Oh, the regulation
that
less number of vehicles.
Coal and iron ores. Those.
Only at the instance of the transporters.
I cannot say without any.
I'm just thinking. Why at all anybody would be aggrieved?
Who is the courageous lawyer who can take up?
He's take up.
Nikesh Puri, my senior man.
Your senior is also very courageous.
He can handle it.
He's saying he will handle it.
Himself is quite capable.
In the present.
If they come to
petition in the nature of
take care of that.
Advocate in the affair.
Litigation. Additional affidavits have been filed, making allegation that the petitioner is being threatened of dire consequences should he pursue the present matter. Stop. After having gone through the records, more particularly the allegations made in the writ petition, we are of the view that the case discloses cause of great public importance. First off, in the facts and circumstances alleged, disclosed in the additional affidavit filed on behalf of the petitioner, we direct deletion of the name of the petitioner from the cause title. First off, the court shall suo motu proceed with the application in public interest. Also, Mr. Siddharth Das, learned counsel, shall assist this court as an amicus curiae. How will it?
The petitioner as well as Mr. Das both have been threatened.
You have also been threatened?
Yes, that allegation is there in the appearance.
Petitioner and
Why is your petitioner bedridden? His only age 45 years? Back problem?
No, already operation ତାର ଗୋଡ ଭାଙ୍ଗି ଯାଇଛି ପୁରା nailing.
Because of an accident.
Yes.
Mr. Monty, can we request you to assist us?
All right, I don't know, let him please.
I'll
request Mr. Hill and senior counsel to assist this court as an amicus curiae. What of the request? Let this to be posted. Deletion of name.
One petitioner also wants to come from despite his person.
Assisted by Mr. Siddharth Das. Mr. Siddharth Das, current counsel. It's complete. A consolidated merit application. Yeah, copy. You're deleting name of the petitioner.
I will collect it from him. Consolidated register.
All right. Hmm? 2 weeks. Please supply to him.
I love.
Item 46.
46% lordship direction. I have already filed a counter affidavit. My friend says that he has not been served upon a copy. So I will give a copy to my learned friend. The counter has been filed on 4/10/2024. I will give a copy to my friend.
It is stated by Mr. L. Samanthil and AGA that counter affidavit has been filed on behalf of the opposite parties. Also, let a copy of said counter affidavit be served upon learned counsel for the petitioner in course of the day. Yes.
We have of the state opposite party. There is private opposite party. Notice has not been issued.
All right, state opposite party.
Item 47.
May it please my lordship. To recapitulate, my lord, a petition was filed also regarding reservation of first service personnel.
Yes, yes.
Not ex-service personnel.
Yes, we remember.
That is a reservation then. Now, your lordship has directed the state to file a counter. State has filed, my lord, it seems nobody applies mine, my lord. State has filed a counter stating that in 2013, there is a decision by this honorable court that that cannot be a reservation within the reservation. That was 2013, the notification, that is the order of preference inside ex-servicemen's reservation. That was challenged. This honorable court directed that there cannot be any preference in between ex-servicemen. But at that time, this 2018 notification has not come. So therefore, I am not claiming a preference within that. I am claiming to be included in the reservation so far as a servicemen are concerned, in pursuance of the circular issued by the ministry. Lord, now, my Lord, the question that short question that falls for your consideration of your lordships, that entry 2 of the first list relates to in armed forces, my Lord. That includes defense, my Lord. And it's under section 51 and 53, the executive power of 73, my Lord. Executive power has been decided. And your lordship sees, may I draw your lordship's kind attention to that letter, my Lord. That is page 28. Has your lordship got it?
Yes.
Enters a priority for reservation preference to the wards of armed forces personnel by state duty for admission to medical, professional, non-professional course. Approval of the competent authority is conveyed to the removal of Juddha Seva Medal series of awards. Institution for admission in medical, professional, non-professional course. The revised list of priorities will be as follows. Lord, priorities 5, your lordship may kindly see. Wards of ex-servicemen and serving personnel. Has your lordship got that? Then, my Lord, priority 8, my Lord. Wards of serving personnel. So this preference amongst them, I am not claiming. I am claiming that this is included by the ministry. And paragraph 2 of that letter, this issues with the approval of Honorable Raksha and supersedes our earlier letter, letter on this subject. So this is the revised list, madam. This includes this. This letter is with the approval of the Honorable Minister, madam. And this is not just a circular of an administrative circular issued by the subordinate officers. If this is issued, my lord, then entry 25 relates to education, my lord. Education and admission into engineering institutes, my lord, of the concurrent list. Then if this central government issues a direction, so far as defense personnel is concerned, my lord, how can they not implement it? And they are referring to 2013 when this letter has come 2018, my lord. And PPL's policy planning body, well, they only say that it is up to the state government to take a call. And since the state government has not acted on it, we are continuing with the old policy. And the state government's objection is that in 2013, this Honourable Court struck down the priorities amongst ex-servicemen, and therefore I cannot be included.
Where is that decision?
Mala?
Where is that decision?
The decision is not there, but they have even Lord. Your Lordship may kindly see.
This I was also appearing in this case, no? They are intra these.
See, this appears to be quite reasonable. That if you have
that's the point.
40 persons qualifying in that category, then how will you choose? How will you give?
It has to be on merits.
It has to be a merit,
But
it gives preference to the widows, first priority, to the widows and wards of defense personnel killed in action. It is reasonable.
Yes, it
that
is.
You give this benefit to the widows and widow wards killed in action. Then second topmost priority is wards of disabled in action and warded out from service. So they priority 1 and priority 2 cannot be clubbed. It is the policy decision of the government to give priority who sacrifice their lives. Similarly, widows wards of defense personnel who died while in service with death attributable to military service. And then it says wards of disabled attributable to military service, and then ex-servicemen and service personnel who are in receipt of gallantry awards. Gallantry awards also, it is
stands on a
They say that servicemen will not be included.
Servicemen, how cannot be? They cannot be.
Mallards, I'll if your lordship permits me, Mallards, I'll
See, they will say that service personnel cannot be included if they don't understand what does Paramveer Chakra mean. What is the meaning of a service?
Mallards, what has happened here?
Understand that.
Mallards, the government initially, that is the reason why government gave all these priorities. What happened, Mallards? It came before the honorable single judge. Single judge instead, Mallards, adopted the principle of merit. Depending on that, Mallards, PD Sharma's case, that only merit and merit alone will be the criteria. Mallards, priority within a category should be avoided because the mandate of TMA Pi and all that is Mallards. And then this judgment of the honorable single judge was upheld by the honorable division bench. So, and then the matter was not. Jay also filed an appeal, which was turned down. Matter was not pursued further. In my learned seniors case, Mallards, all these judgments may not apply also because they have done, they have added to that category. Earlier, the ex-servicemen were not there. Now they have said in the horizontal reservation, the servicemen are also added. So if they're added, if the central government has added, it's my, Mallards, as a council, I would, Mallards, submit before your lordship that the state government should be following that because initially what the central government did, the state government followed. Then whatever modifications come in the central scheme have to be, Mallards, followed by the state government is my submission.
Fair enough.
That basis, Mallards, my learned seniors case should be allowed in this.
What relevance to that 2013 judgment has to this case?
This judgment will not stand in the way of the relief being sought for
relevance,
by my learned senior.
We're talking about 2018 this circular.
That has added one level. So therefore that should be followed.
When was it filed? Recently?
Well, recently it has been filed,
So they have not upgraded themselves.
Your Lordship, the earlier, initially in 1994, a letter was issued by the central government, Your Lordship. There was a priority list to give to the service personnel also. That was priority number 7. Now, after that, then the government of Odisha also has a policy. They have taken out an act which says that, Your Lordship, it is the Regulation of Admission and Fixation of Fee Act 2007. In that, they have a policy planning body, Your Lordship. There, the policy planning body in 6/1/2014, Your Lordship, they issued they took a decision to do away with the prioritization policy and also the reservation for children awards of servicemen, Your Lordship. So in 2014, this is being carried on. And they increased the quota for...
also.
No, Your Lordship. They did away with that priority number 7 of awards for servicemen, Your Lordship. Ex-servicemen only.
There was no such priority.
Yes, 1994 there was.
No,
1994 letter.
Let me assist my...
No,
letter. 1994, Your Lordship, Annexure A/4 to my counter, Your Lordship.
2013 challenge
no, 1994 till 2008 and 9, it continued. Service children, awards of service personnel were given reservation, Your Lordship. But after that judgment of 2012 and 2013 in the writ appeal, after that, this decision was taken by the policy body of the Orissa government, stating that they did away with the reservation policy for service awards of service personnel, and they increased the quota from 2% to 3% for wards of defense personnel, ex-servicemen, Your Lordship. Now, Your Lordship, to these letters of the, as per my instructions, these letters are all executive instructions. These colleges are of state government, funded by the state government, and the state government has a right to make the policies. And Your Lordship, a comparison chart also I have given in my counter. Out of 9 states, only 2 states have taken into consideration instructions given by the central government. Other states have also in their own, they are having their own policies, their own sets of reservation policies, and whom to give, whom not to give. But this priority for wards of service personnel, that was done away with in the year 2014, Your Lordship, by the state government, taking a decision by the policy body, Your Lordship. Under the Act, they did away with that reservation, Your Lordship. And 2018's letter is the same as 1994 letters, Your Lordship. It's the same. The same prioritization has been given. But the state government, as per my instructions, the state government says these are our colleges funded by the state government, authorized by the state government, and we have the right to
There's
take
someone
a
for
decision.
Union of India.
So
Union of India is a party.
that is all. They said that these are not, these are all executive instructions, and they cannot be binding on us.
Whether the Union of India is a party in this.
2014 letter, I'll tell you, Lordship.
Whether Union of India is a party in the present litigation.
No.
No,
Rajya Sainik Board should be a party.
Your Lordship, look at entry 25 of the concurrent 7 schedule. It reads as this, my Lord. May I place it?
No, not that is not the question. The question is, can the reservation policy for admission to medical colleges be decided by the Ministry of Defense?
No. So far as the reservation regarding the serviceman or ex-serviceman is concerned.
Very difficult. Very difficult to accept that contention, because that concession can be given by the state government, of course, at the instance of the central government or on the
that is always given. That is their case also.
Therefore, it would be better if, and what she is saying, that in none of these this has been implemented.
No, I think she's not correct.
Except 2.
In Orissa, my lord, the situation is not that. Let me just take your lordship to 1 minute, my lord. Lordship, bear with me. Page 25 is what she's referring to. 18. That letter of 2014 laying down the policy of the policy planning body, my lord, that's 2014 letter. That letter reads like this, my lords. In conformity with the prioritization policy for admission to medical and professional colleges in respect of wards of different category, communicated by the Ministry of Defense, Government of India, via the DO letter number so and so, dated 3/6/94. This is referring to. And that letter, my lords, refers to 6 categories. 6 categories. And then this letter says, since the Medical Council of India and regulation and the decision of the apex court strictly adhered to the authorities to follow up and adhere to the merit list while giving admission to MBBS and BDS courses only, and reservation within the reserved seats are also not admissible, which is this 6 categories.
No, Your Lordship, that is 7 categories.
Let him come.
7 categories.
Let him.
Therefore, adopting another procedure ignoring the merit list is illegal and violative of the rules of merit for admission into MBBS course. The Honorable Division Bench of Orissa High Court, via judgment dated 27/9/2013, passed in writ appeal number 386 of 2013. This is the very same judgment I am referring to, my lords. Confirmed the aforesaid judgment dated 13/11/2012 of the learned single judge of the Honorable High Court of Orissa. So that judgment, your lordship, is, my lords, I just passed on. That is on which this policy has come. It is not in dispute. Nobody's case that they have not adopted the Defense of India, my lords, central government ministries my lords, policy of reservation. Now, this Ministry of Reservation itself adds, my lords, your lordship will find in this category, it has been referred to in that judgment also, it refers to only 6 categories. Now, here, 2018 letter, page 28, your lordship will find, for the first time, 7 categories, I'm sorry, for the first time, a category 8 and category 9 have been added. That is what my learned. So now, if you have adopted 94 central government ministries in my lords.
Oh, that is the question, whether this
That is the
communication
question.
binds them.
My lords.
Whether if there was a policy of the central government, they accepted that.
My lords.
Whether that policy of the central government was binding on the state government, that is the question. Whether because of that communication, the state government is bound to take a decision
No,
in a particular
therefore, my lord,
manner.
my lord, therefore, to take that question little further, that argument little further, that reasoning, then they have to do away with the entire reservation for
that they have to decide. See, the provision for reservation under it is not 16(4) or so. That is enabling clause that does not compel.
No, that right, very.
So therefore,
there's no dispute on that. There's but this argument here is this, that if you are adopting the central government directive to give it to one category.
It cannot be a legal reasoning that because you have adopted, therefore you are bound to adopt. Legal reasoning is that was adopted because it was compulsion, and therefore subsequent amendment that is also under compulsion. They will have to, and then only the court can issue direction.
Yes, my lords.
Otherwise, of course.
So therefore, this has been superseded in 18. So therefore, now this policy has been superseded. The earlier policy of 94 has been superseded in this 18 letter, May 21, 2018. This supersedes the earlier policy.
All right.
So now they have to adopt this one.
This has not been taken into consideration, and they say that stick to
18 just replaces that 14. 94. 94 has been just replaced by 18.
Your Lordship, if I may place the letter of 1994, Your Lordship, that is Annexure A by 4, my counter affidavit filed by opposite party number 4, Your Lordship. That states that the state government have provided for some, they're saying that it is compulsion. So I'm just reading out the language there. State governments have provided for some reservation or preference for admission to medical or professional colleges for the wards of different personnel. It has been noticed that the order of preference differs from state to state, and in many states, the preference list does not include wards of gallantry award winners, ex-servicemen, and serving personnel of armed forces. Thereby, the seats reserved for defense category are not utilized and are transferred to general pool. Though education is a state subject and universities are autonomous bodies, standardization of preference for admission in defense quota is desirable. To bring about uniformity in the state duties for the purpose of standardization, the following prioritization is recommended, Your Lordship. There they had the priority 7, wards of serving personnel. This was continuing till 2008-9. After 2014-15, this was done away with by the policy body making decision of the state government under a legislation, Your Lordship, under an act. So in the absence of any legislation.
Where is that act?
That act is, Your Lordship, that is, I have quoted the act.
No, it was not done away with.
If it is an act, there must be objects and reasons. Why
Yes,
did
Your
they
Lordship.
away with it?
It was not done away with under the act.
No, not under the act. The act came into force in 2007. The Orissa Professional Education Institutions Regulation of Fee Act 2007. There, Your Lordship, under this act on C6D, the policy body exists, Your Lordship, it takes decisions. That body took the decision in 2014 to do away with reservation for wards of service personnel. And that has been continuing till today, Your Lordship.
No, 2014.
Yes, Your Lordship.
All right.
Yes.
Have you taken into account the communication made in 2018?
Yes.
This 2018.
Yes.
2018. That is the only question.
Yes, Your Lordship. That it is not binding the executive instructions of the central government.
We may not direct the government to do a particular thing in a particular way, but we can surely direct them to consider at least, to take a decision, to say why not.
Yes, Your Lordship, that can be done. I
Next week.
It is for the policy planning board to consider.
Yes, the policy planning body is to consider.
This decision, ultimately what direction?
Direction is that gallantry award is this, this prioritization should go.
Intra prioritization should go, but the adoption is the intact.
Reservation so far as
reservation has not been touched.
Intact. But the prioritization within that.
Para 11,
that is also, it was not argued then that it is a rationality.
That is quite reasonable.
That is
nobody argued reservation, you honor.
Nobody argued.
Yes, and that was nobody's case also.
It is not a kind of reservation. It's kind of honor which you give to someone who lays his life.
did away with the reservation for wards of service personnel and the increased reservation from 2% to 3%. And that has been continuing till date.
Consider it carefully, then there is no difference between a person who dies in a war and the person who gets Paramveer Chakra. They are almost at the same pedestal.
Who's exposed to that danger every day. Serving
Paramveer Chakra means he risked his life.
Every day is that risk is there.
And not only that, for that, the incident for which he is granted Paramveer Chakra, he risked his life in the interest of the nation.
That is
therefore,
rationally.
Because of the policy of the government, our hands are tied.
All right. Our hands are also tied.
Government has tied its own.
That about that submission that education is in the state list, that is not exactly correct. It came, my lord, from 76 onwards, my lord, education, including technical education, medical education, and university, subject to the provisions of entry 63, 64, 65, 66. List 1, vocational and technical training of labor, all falls in the concurrent list.
Yes. Put up for orders.
Policy planning body party hai.
Item 48.
No, no, I'm JEE paying. Policy planning body. If your lordship permit, can I suggest to my learned senior to add that policy planning body as a party right now so that your lordship.
Policy planning body is of the government.
Of the government.
It's a separate. Direct the government to place it before the policy planning body.
Place it before the policy planning body. Grateful.
Obliged.
Good.
Item number 48.
Question 48, of course, nobody is there. But in this writ application, they've challenged the rejection of their bid in the tender condition. But so I have instruction that the tender finance committee has recommended to the state government to cancel the entire tender. So, but no final decision has been taken by the state government. Lords may call it sometime. I will obtain instructions regard to the.
There is no representation on the ground.
I'm appearing for item 48, Your Lordship.
You are for?
I am for the petitioner, Your Lordship.
Yes.
For item 48, yes, Your Lordship.
What do you want?
No instructions, no reply has been filed by the state, Your Lordship. No counter has been filed.
Nobody is saying that they have decided to cancel the tender.
That must be, my lord, I am appearing from the OP number 5, Your Lordships. That must be with the affidavit, my lord. There is no, my lord, because my case was considered because he has been considered, my lord, documents of that what my learned senior is saying, that must be with a document with the affidavit.
Yes.
Yes, I have got the document saying that the tender committee has finalized that it is recommended to the state government to cancel the process of tendering.
But
so
that
now
can be, that may not be
State government has not yet taken a decision.
So that's why saying that Lords may grant me some time so that I can obtain.
Requested on behalf of the state to list this matter on 2 weeks.
Yes, no.
Item number 50.
A dash, A dash. Yes.
Item 50.
In this case, your lordship, issued the notice to the contesting opposite party with the opposite fact number 3.
Someone is appearing.
By 28th of August 2024. Order
Someone
number
is
1.
appearing.
No, Mr. J. Katkia, in fact, he had telephoned to me. Perhaps he has missed the list. His name has do not
All right,
appear.
tomorrow we will take up.
Okay.
Let's just matter tomorrow.
Item 51.
This matter, my lord, pursuant to lordship, has a copy or served on me. Copy of the writ petition I received, my lord. I sought for some time to file my counter affidavit. I am for OP number 3, the chief administrator.
May I make a submission? Lord, the writ is drafted on the basis of rules my lords were referring the last time, the Odisha minor mineral concession rules. It has come to notice that there is error in the rules that are published in the book. I have collected a copy of the Gazette notification. A subsequent amendment of 22 is not incorporated in the books that are available. So, in fact, the amendments strengthen my case. So, I would seek leave my lords to amend the writ petition. In fact, the question, if my lord remembers, the question is of jurisdiction, because the issue was there is a provision for appeal under the OMMC rules. The impugned order was of cancellation of a quarry lease and a demand notice for excess raising of building stone. So the orders were passed by the sub-collector competent authority. It was the order of cancellation, and the demand notice was by the officer on special duty of the Sri Jagannath Temple administration. Now, on the last occasion, this question was raised, and the 22 amendment, 27/12/22 amendment, which is not reflected in the books, it provides for transfer of the administration of minor minerals to the Steel and Mines Department from the Revenue Department.
Yes, please.
Yes, please. So I
are listening.
Yes. So, my lord, these amendments are material. These amendments are material, basically a question of law. So, I would seek permission of my lords to amend the writ petition.
Do that.
Yes.
One week time, how much?
A week's time.
1 week time is allowed for current counsel for the petitioner states that an amendment application is required to be filed in view of statutory provision which had gone unnoticed while drafting the writ petition. Most of, as requested, let's this matter on 2 weeks.
Yes.
And you kindly bring to our notice which are these publications have not incorporated these amendments.
I have been pursuing with the publications.
No, we will also see if in a library they have provided proper.
The other day, my lords were referring to the OLR version. That
book is not updated, my lord.
No, then we should not take books from those publishers.
And the other publication also is not complete.
They just give on the cover sheet, they will give the year without updating.
In fact, it is not available in the library here nor in the government press, the second amendment. So
Why?
My lord.
In the government?
Yes, because my clerk had visited the government press for there were two amendments. One on 27/12/22.
Those gazettes must be available.
Gazette is available.
One gadget I have been able to collect, that is 27/12/22. The other amendment which is incorporated in the book, the gadget copy I could not for
No,
them
no.
to
Gazette
confirm.
has been published, but you could not get a
Yes, ma'am.
copy.
Yes.
Yeah, okay.